Yes.
Oh, turn on my mic. Okay. Thank you. Okay. Has anyone indicated a desire to speak?
Mr. Gallant has, and I believe he is on Zoom.
Okay, Mr. Gallant, can you hear us?
Yes, can you hear me now?
We can. You have 2 minutes.
Okay, thank you very much.
Mr. Fracassi is timing you.
Okay, thanks, Adam. Be good to me, be gentle, okay? Madam Chair, James Gallant, Marquette County Suicide Prevention Coalition. These are my opinions. I'm still waiting for the AG opinion concerning the Roberts rules being required by public bodies in Michigan, as it was determined by Mike Brady, the Director of Legal Services, on September 17th, 2020, for the Independent Redistricting Commission. It's in the transcripts, and I think including the chapters on the Secretary and the Chair and the Parliamentary Law all apply here. And you were going to get us an AG opinion, and I haven't got that back on their listserv. They say new opinions come out on a listserv, so please schedule a public hearing to approve the language for that request from this board to the Attorney General, and then you could give us a chance to, and get some input. And I believe the petitioners today here have a right for the commissioners to understand the question before them. You don't have a question before them. It's consideration for something. No, under Robert's Rules of Order, and Jonathan Brader has already determined, it used to be a specific yes or no question before you, and that's page 3666, line 8. No debate before a motion second. Okay, so the question is, it's listed on the agenda. It should be approval of the petition as sufficient. Yes or no. If you disagree, vote no. That's supposed to be the question. Whoever wrote this agenda, this doesn't comply with Robert's Rules of Order. So by example, yesterday at the Independent Citizen Redistricting, Commissioner Eads stopped the mapping, suggesting that we change the numbering for like 20 minutes. And then the lady said, well, Madam Chair, I call the question. So Commissioner Eads said immediately, there is no question. So exactly, you have no question before you. So that's a violation of our parliamentary common law in America. You have to have one question at a time, and your statements need to be germane to that immediately pending question. That's what you're here to do. That's your job, your duty, and responsibility in the Constitution. So please get us that Attorney General opinion so we can settle this in our communities. This is what's destroying the fabric of our community, is interpretation of Robert's rules. And you saying, well, on longstanding, for decades, you've been hiding behind this. Well, it doesn't necessarily apply. We need to find, does it or does it not? Because if it does, then you need to change your position and how you do the business here. Because Robert's Rules is the highest ethical standards of business practices in the United States, because it's determined under our Constitution. It's a direct, interpretation of our Constitution. So that's how it works in our society. That's how it works. So please help. Please help us here. Can you do that for us, Madam Chair?
Thank you, Mr. Gallant.
Thank you.
The next item on the agenda is consideration of the meeting minutes for the December 18th, 2023 meeting. Do we have a motion?
Madam Chair, I make a motion to approve the minutes of the Sport Michigan Board of State Canvassers meeting on December 18th, 2023.
Support.
All in favor? Aye. Motion carries. The next item is consideration of the sufficiency of the recall petition submitted by Chad Bosse against Governor Gretchen Whitmer. Mr. Trebilcock has indicated that he wishes to speak to this issue. Mr. Trebilcock? Yes. We have not heard, we do not have any indication that Mr. Bosse wants to speak to this matter. Look at that first.
I didn't know I could participate by Zoom. That would have saved me some time this morning.
Wait 1 minute, Mr. Trebilcock. Mr. Trebilcock?
Good morning. Great to see you guys again.
Let me just remind you and others that we have carefully read your position letter. And we have a lot of items on the agenda.
Yes, ma'am. Good morning. Mr. Fracassi just handed me something that apparently Mr. Bosse sent in, which appears to be something from a website. from City of Albion saying that he is registered. I'd like to just present to the board, and this was contained in the link that I had sent, but my understanding is that some of you weren't able to obtain it. This is the voter registration from San Diego County Registrar of Voters, indicating that on June 5th, 2023, Mr. Bassi registered in San Diego County. So Mr. Bassi trying to assert that he can vote here in Michigan and also vote in California is either perpetrating a fraud on the state of California or he's perpetrating a fraud here on the state of Michigan.
Let me interrupt you for 1 minute. Member Bradshaw has indicated that we should read into the record the language that Mr. Bassi has submitted before we hear your comments about it. So let me do that. The language on his recall petition is as follows. Governor Gretchen Whitmer has budgeted funding for law enforcement throughout Michigan that enforce Michigan statutes that have similarities to slave licensing, black codes, and Jim Crow laws without adequate safeguards to prevent from discrimination against low-income individuals and communities, echoing the behavior of slave traders against those of color. That is the first reason on the petition. The second is Governor Gretchen Whitmer has had direction over the Michigan Department of Agriculture, which licenses immigrant labor camps, but denies many of the immigrants a driver's license, which can entrap foreigners.
Thank you, Madam Chair. And I will not repeat the arguments and certainly refer to them in our response on the failure to meet the standards under the election law on why those two reasons that you state lack sufficient clarity and fail to meet the standards under the recall statute. We detailed those therein, and I trust that you understand and happy to answer any questions you may have. But I do want to focus on the preliminary issue of whether Mr. Bassi is even eligible and qualified to be able to submit a recall petition in the state of Michigan to begin with. And as they like to say, it's best to start at the beginning. You may be familiar with that. I believe Winnie the Pooh says that. Article 2, Section 8 recalls in the state constitution. Laws shall be enacted to provide for the recall of all elected officers except judges of courts of record upon, and here's the key phrase, petition of electors. Petition of electors. That's Article 2, Section 8. The Constitution also provides Article 2, Section 1, qualifications of electors. So under our Constitution, to petition a recall, you have to be an elector, and our Constitution defines what the qualifications to be an elector are. And those qualifications are, you have to be a citizen of the United States, and the text of our Constitution says age 21. That has been superseded by the U.S. Constitution that says you have to be 18, who has resided in this state 6 months, and who meets the requirements of local residents. Again, that term residence and resided, provided by law, shall be an elector and qualified to vote in any election except as otherwise provided in this Constitution. The legislature shall define residence for voting purposes. So again, to be qualified to submit a petition to recall an elected officer of this state, you need to be a qualified elector. So, qualified elector, echoing the Constitution, MCL 168.10 defines qualified elector. You must meet the requirements of Article 2, Section 1, which I just read, as well as you have to have resided in the city or township that you live in for at least 30 days. MCL 168.11 in as directed by the Constitution, defines what it means to be a resident and have residence. It's where you habitually sleep. It's where you keep your personal effects. It's your place of lodging. It is where, and the case law is interpreted to this to say, it is where you, even if you leave, it is where you intend to return. Now, talking about registration, to be able to register to vote, MCL 168.492 says you have to be a resident of the state and a resident of the township. Again, you have to be the place where you habitually sleep and keep your personal effects. We've provided evidence to this board that Mr. Bassi is a resident and lives in Tijuana, Mexico. He's not even doesn't even live in this country, and is a resident of Tijuana and is registered to vote in the state of California. We have provided you the official printout of his voter registration from the state of California. We have provided a news article with a photograph of Mr. Bassi where he is quoted by the news as stating that he lives in Tijuana and commutes to San Diego. That is sufficient evidence for this board to deny and conclude that Mr. Bassi is not a qualified elector as required by our Constitution and the election code. Now, you may have heard, and you may say, well, hey, he submitted this piece of paper that says he's on the voter polls here in Michigan. You may have heard from the director of elections that, well, he's still on our poll book because of the National Voter Registration Act and the Help America Votes Act. Well, that's a red herring. Does that matter? No. Because the National Registration Act and the Voter Registration Act, by its terms, applies to qualifications for federal elections. It does not govern and supersede our Michigan Constitution. To hold otherwise would say we're beholden to what the federal government says about our recall petitions. Let's even say that his voter registration is a factor to consider. MCL 168.505 allows our Bureau of Elections to cancel a voter registration. How do you do it? Two ways. Authorization signed by the elector and received from the other state in which the person is registered, or two, notice from an election official of another state that the elector registered in that state. In this case, you have notice from the San Diego Register of Voters. I have provided you with that notice. It is their official website. And not only that, I provided the Bureau and this board more than 2 business days ago this notice. There is no reason that this board or the Bureau could not have picked up the phone and called the San Diego Register of Voters and said, hey, we received information that a Chad Everett Bassi, previously registered in the state of Michigan, has registered June 5th, 2023, attesting under penalty of perjury that he resides in the state of California and has registered to vote. Is that correct? And if they would have said yes, then we would remove him from our polls. I don't know if that has occurred or not, but this board has notice from the official San Diego County Board of Electors or Register of Electors that Mr. Bassi is a resident of California and is registered to vote in the state of California. Now, the state of California law requires that Mr. Bassi, when he registered, inform the state if he is registered in another jurisdiction. He has to affirm under penalty of perjury that he is a resident of the jurisdiction that he is registering in, and he certifies under penalty of perjury that that is all truthful. You can look at Chapter 2, California Election Code, Section 2150. Chapter 4, California Election Code, Section 349, defines what residence is. It mirrors Michigan's, that it is the place where you habitually sleep, keep your belongings, intend to return, all those things. The law is almost identical. Here, the election official of San Diego County on its official website states that Bassi registered to vote on June 5th, 2023. He swore under the penalty of perjury that his residence was in California, in San Diego County, and he also listed, and it's required on the form, and I have it if you want to see it, where he was previously registered. It's required under California law. And at that point in time, he was no longer a qualified elector under our Constitution. And therefore, he cannot initiate a recall petition under our Constitution. Where do we start? We start at the beginning. The Constitution. The Constitution is what gives us the right to recall in this state. The Constitution requires you to be a qualified elector. The Constitution defines what a qualified elector is. And Mr. Bassi, at the time he submitted this recall petition, was not a qualified elector. Moreover, this Bureau and this board has been provided sufficient information to remove Mr. Bassi from the voter registration polls, therefore furthering evidence that he is not a qualified elector and cannot submit a petition under the Constitution or the laws of this state. Therefore, we would urge this board to follow our Constitution and declare that Mr. Bassi is ineligible to submit a recall petition until he reestablishes residency in the state of Michigan and re-registers and confirms that with the Bureau of Elections. Thank you.
Questions?
You mentioned the information about, registered in California. We get this piece of paper, looks like it's just January 19th at, I don't know what that is. Thank you. Man, I should have brought my readers.
Get longer arms.
So even if he did register and he's reestablishing, the issue you raised about, I heard you mention 30 days and 6 months. So
Correct.
regardless of the reestablishment, your argument still holds that it's invalid.
Correct. The voter registration, I think, is a red herring issue. That whether you're still on the polls or not, that's required by the Help America Votes Act and the National Registration Act. And there's specific guardrails so that people aren't improperly removed from the polls. Now, what that permits under the statute is if our Bureau gets notice and written authorization from the voter, hey, I've registered down in Ohio, take me off, I'm no longer a Michigan voter. They get that, or the Bureau of Elections, some states require it. Michigan, as part of your registration process, and they can correct me if I'm wrong, you sign an authorization that says you're to notify the other state that you're now registered in Michigan. I dug as much as I could. California obtains that information. I couldn't find anything, at least in the statutes, maybe there's a policy or procedure I couldn't locate, that affirmatively requires them. I'm not sure if the Bureau received notice independently last June or since June. But as of today, Mr. Bassi, and from all knowledge that we have, lives in Tijuana, is a registered elector. His last voter registration is in California, San Diego County. That's one piece. But all evidence that we have, and I can provide it, his Facebook page lists that he lives in Tijuana. All his pictures are talking about being in Southern California and Tijuana. He is not a resident in this state, and he is not a qualified elector under the Constitution. That's the standard. This board is charged with the national voter registration, whether he's on our polls or not. That's a separate issue. Whether he's properly removed. The issue before this board is the Constitution. And the Constitution requires you to be a qualified elector. And we've provided evidence that he is not a qualified elector because he's registered and resides in another state.
This isn't some instance where there's another Chad Bassi who is just, happens to share a name and you're confusing him. This is crystal clear.
What I submitted to you is Chad Everett Bossy, date of birth, I believe it's July 18th, 1980. To refute any of those questions is why we submitted the news article that includes a picture of Mr. Bossy that matches Mr. Bossy's Department of Corrections booking photo for when he was imprisoned. The pictures are identical, so I don't believe there's any question that Mr. Bossy living in Tijuana and residing in the state of California is any different than the one that used to be here in Michigan.
I did also compare Mr. Bossy's Department of Corrections photo to the one in the news article which you sent. But it's my understanding that Michigan law, in order to cancel a voter's registration, is essentially compliant with the National Voter Registration Act. And while I think that Mr. Bossy may have a serious problem in California if he didn't indicate that he wished to terminate his Michigan registration, because he could have, I know in compliance with Michigan election law, when one changes one's registration or goes to register in a different jurisdiction, one can authorize and is expected to authorize cancellation of a previous registration. And you indicate that that is the case in California as well, but there has been nothing sent from California, so far as I know, to indicate that Mr. Bossy has authorized the cancellation of his Michigan registration. And in fact, it appears to be still existent. So I don't, my legal opinion here, but my opinion is that so long as his registration is not canceled, he's registered in Michigan. He may have serious problems in California. I hope he does, but I don't think we can find that he's not a registered voter. I understand what you're saying, that you're saying he's not qualified to be a registered voter any longer, but he's still a registered voter.
Let me refute and push back on your legal analysis in two parts. One is, as you note, the standard under the Constitution is not, is he a registered voter under the National Registration Act? That's not the standard. The standard is he a qualified elector, and you have to look at that definition. And his voter registration is but one piece of evidence to determine whether or not, when he submitted this petition, is he a qualified elector? And second, I think you forgot the second piece under the federal law as well as under state law. It's not just that Mr. Bossy authorizes his removal. It is as if this bureau receives notice from another election official. Notice is not defined in the federal law, and it's not defined under Michigan law. You have notice, and you've had notice for 3 business days. If there was any question about whether or not Mr. Bossy, because I've provided the official printout from the San Diego County.gov website confirming Mr. Bossy's registration, this bureau now has notice from the San Diego election official that Mr. Bossy is registered in another state. Now, if there's any question of that, the bureau could have taken the time to pick up the phone and confirm that, and then the notice would have been received. There's nothing in the statute that says it has to be sent by certified mail, it has to be faxed. It says notice. And notice has been provided from the official San Diego County Register. So if, in your opinion, voter registration is what is determinative, then I would say it's not valid. But let's just take for consider a moment. Michigan law is clear that we're not to interpret statutes or the Constitution that reach absurd results. To take your conclusion that says, look, if you're on our voter polls, you can recall our elected officials. The only way you get removed automatically from the voter polls is if you don't vote in 2 federal elections and then don't respond to a card that we mail you. That's at least 4.5 years. So I can move to Alaska, register to vote in Alaska, and sit in Alaska and try to recall elected officials in Michigan for 4.5 years. That is an absurd result. That is an absurd interpretation of our Constitution and the Michigan election law. And in this case, I don't understand why we're bending over backwards when we've got documentary evidence that the man is registered to vote in California and lives in California.
I don't understand the information that you provided to us to constitute official notice from California that he has authorized the cancellation. I mean, so far as I understand, the state of Michigan, and particularly the clerk of Albion, where he is registered, has not received any notice from California.
Did you confirm that with the clerk from Albion?
The clerk from, I asked Mr. Fracassi whether Mr. Bassi was still registered, and he confirmed, as he did with you, that he is still registered. And, you know, that has been confirmed. But my concern is for the voters. And I understand your concern that Mr. Bassi is living in Tijuana and trying to recall Governor Whitmer, which is it's a difficult circumstance for us to deal with, but his registration is valid until it's canceled in accordance with the National Voter Registration Act, which is also adopted by the state of Michigan. So I think
it's a different standard. I would urge that it's a different
and
standard.
I don't think
that
we
gets
can
applied.
say he's not qualified to be a registered voter if in fact he's a registered voter. That is not a determination that we are able to make.
A qualified elector. It's not registered voter, it's qualified elector. And how that is defined by the Constitution is that you have to reside, residence. And you now have evidence both from the voter registration and the news article where he states that he lives in Tijuana, that he is no longer a Michigan resident.
Any other questions?
Yes, it's not necessarily related to the residency issue, which I think is, in my mind, beyond compelling. Don't let it go to your head that I agree so strongly with you. There's in one of the various news articles on Mr. Bassi and his recall efforts, and I'm familiar with him because having served on this is now my fourth year, and he's a habitual submitter of these. This article starts out, the Albion man who recently filed his sixth recall petition against Michigan Governor Gretchen Whitmer told the Michigan Advance, the effort is more focused on trying to get his driver's license reinstated than it is about actually gathering signatures and following through with the petition process. My question, whether it's for your interpretation or from our staff here, is that type of statement and information enough for us to reject his submissions because they indicate a lack of seriousness and that they are essentially a nuisance effort? Or is that I'm careening off into an area that maybe we shouldn't consider? So I'll ask for your interpretation, and then from Mr. Brader, kind of what the thinking is.
You sure don't want to hear from him first? No.
Sure.
Well, I might have to kick it to Mr. Grill in terms of your legal options. But I think that I don't know that there is a specific section of the election law that contemplates the seriousness of the effort. I think it speaks to the reasons for recall, the clarity and the factualness of those, and the conduct in office. I'm not sure if the motivations of the person are something that is contemplated by the election law, but I don't know, Eric, if you have anything you want to add.
I'm unaware of a case specifically dealing with the motivations of a sponsor, but there are a long line of cases in Michigan going way back, even several versions of the Constitution ago, to the point that the sufficiency of the grounds of recall is not something that should be considered. In the current Constitution itself, the last sentence says that the sufficiency of any statement of reasons or grounds procedurally required shall be a political rather than a judicial question. This has long been held to be the idea that, you know, it is not for us to decide whether or not the reasons are good reasons or not. It is simply, do the reasons meet the requirements in the current statute? I believe that is clarity and factual. So, thank you.
You know, because there are a lot of people here who have not dealt with recall before, apart from the issue that you have raised, Mr. Trepilcock, with regard to Mr. Bazzi's residency, what we are required by the statute to find is whether each reason for recall stated in the petition is factual and of sufficient clarity to enable the officer whose recall is sought and the electors to identify the course of conduct that is the basis for the recall. And I know that you sent us a position letter saying that in addition to considering whether Mr. Bazzi is a qualified elector eligible to file a recall petition, you have said that the petition is not of sufficient clarity. And I think that people need to understand that that's also an issue which we're considering. I think we could find without necessarily addressing I guess the petition, in my opinion, is not clear. I mean, that was evident to me when I read it a week or two ago when it was sent to us. And so I think we would find that it is not, I expect that we would find that it is not of sufficient clarity. Can we have some discussion on that?
If I could weigh in on that one, because
Yes,
I was waiting
please.
for you on that one.
Madam Chair,
Okay.
if I could just briefly, I do want to address Mr. Don's question, if I could, just briefly.
Please.
Which is, I agree with what Director Brader and Mr. Grill said, that as far as the election law goes, in terms of the seriousness of the effort under the election code, that at least the language is a political question, whether the reasons. However, the Bureau has issued a declaratory ruling where the seriousness of the election effort or recall effort and whether they're actually gathering signatures is relevant under the Campaign Finance Act, and whether or not you can go and raise money. And they've used that in part of their determination of whether there is a special election recall period going on for recalled officials. So I do think it's a relevant issue and a relevant question. The Bureau has made it a relevant question through their declaratory ruling on the Campaign Finance Act. But I'm not sure it plays for the issue before you today. But just to quickly say, as you recognize, Madam Chair, I think there's multiple reasons in addition to Mr. Bazzi not being eligible to file the recall petition. The recall petition lacks sufficient clarity. It is rife with opinions and conclusions and not stated factually. There's also, it's unclear as to what term or when the alleged conduct took place, as well as using several ambiguous terms and phrases that would justify this board rejecting the petition.
It would be in our interest to say that Mr. Bazzi is not eligible to file a petition because he has indicated that he wants to continue to do so and to require us to continue to address these. But he's a registered voter, in my opinion, so he can do it. But do we have any motion?
I agree that this is, like you, when I first saw it, I was like, this is not factual or clear in any way. I do, however, have a strong belief that the evidence is pretty overwhelming that he is not qualified to be submitting these. And I would prefer that the rejection be based on that than the actual language. And I'm curious what obviously I know where you are, Madam Chair, but
Is it possible to reject this on multiple basis? Is it possible to make?
When we make the motion, we have to make the motion on why it isn't factual and clear, right? Yeah. But I think, Tony, where you're going is you rather go with the other one so that we're not coming back here again on clarity.
Essentially, yeah,
It-
because he's clearly not, based on this evidence, he's clearly not qualified to submit these.
If I might make a suggestion, perhaps two motions, one on the clarity issue and one on the eligibility.
Madam Chair, I'd like to ask, I'd like to ask if if the second one is even an option through our legal counsel. Sorry, Eric.
The question, I think, if I could help, I think the question is, does the board have authority or can the board approve a motion to reject or dismiss the recall language on the basis that the individual who filed it is not a qualified elector in Michigan?
Kind of nested, I think, within that is the suggestion that the board, I think, make a series of determinations. First, that Mr. Bazzi is registered in the state of California. Second, that his registration in the state of Michigan is improper. That Mr. Bazzi's registration he is not an eligible voter in the state of Michigan. And then lastly, as a consequence thereof, that he is not able to submit a recall petition, and that this board then has the authority to reject it on that grounds. I have not found any statutory authority suggesting that this board can cancel a voter registration.
I would just say again, I'm not asking this board to cancel Mr. Bossi's voter registration. The determination is you go back to the beginning. What does the Constitution say to be an eligible person to petition a recall? It's an elector. The Constitution defines what is a qualified elector, and Mr. Bossi does not meet the definition of a qualified elector. He may still remain on the voter polls and not be a qualified elector. He could be challenged if he tried to vote here in Michigan as not being eligible. There's processes and procedures for that. That is not what I'm suggesting the board do. And I would again say, if this board doesn't have the authority to make that determination in regards to recall petitions, who does? When does it? So this board is just going to consider if Joe Schmo in North Dakota submits a recall petition, who screens that? Who makes the determination? Who makes the decision? And who gets to appeal that decision? And when does that notice go out? I've never received, and I've handled many recall petitions, both before this board and locally. At the local level, the individuals sign a submission that certifies they are a registered elector in that district, that they're eligible. Because remember, on the local level, it's not just whether you're a registered voter. You have to be a registered voter in that jurisdiction of the officer you're trying to recall. In this case, it just happens to be statewide. So, you make the determination and you go by voter registration. What if the person hadn't changed their registration, and they actually live in Grand Rapids, they've lived there forever, and they're just voting absentee from Royal Oak. And they can therefore recall people in Royal Oak to their heart's content? That's not the standard.
So you're saying that in local jurisdictions, the voter is required to sign that they are a registered voter in that jurisdiction.
The local
But
clerks.
not that they're a qualified and registered and voter in that jurisdiction.
I believe it's qualified and registered. They're a qualified registered elector in this jurisdiction. The
Well,
standard is a constitutional one, not a voter registration one.
And what I think, okay. Mr. Grill has, I think, answered our question, but I'm not, the question posed by Mr. Hauskamp, that is whether an issue before us is whether he is a qualified voter, even though he is, you're suggesting is not.
Elector.
Whether he is a qualified elector in the state of Michigan. And whether we could reject his petition on that basis. So Mr. Grill has suggested that that is not a basis for rejecting a recall petition. Is that correct, Mr. Grill? I'm not sure if you waffled a little bit.
I smelled waffle.
Maybe if I could try to buy Mr. Grill some time, I don't know. But I mean, just to weigh in on, because I can't give you the legal answer to that. But you know, practically speaking, the screening that we do is we check to see if they're registered to vote. I don't, and nobody at the Bureau of Elections has the ability to know in real time whether anybody is at this moment a qualified elector in Michigan. We don't know if, you know, yesterday they moved to another state and that data hasn't come to us yet. So we use the qualified voter file because that's the only practical tool we have to tell if somebody is qualified here, if they're registered to vote here. It's certainly true that for many individuals, they may have physically relocated to another state, and there may be a lag time as required by both state and federal law before we can cancel their registration. There are ways where we can immediately cancel a registration if the individual authorizes it themselves. They contact us or their clerk and they want the registration canceled. Another state can give that information to us, but for it to be an immediate cancellation, we don't just need their name. We need to see the registration form they signed. We need to see their signature because we need to make sure that that person actually authorized the cancellation to immediate, and that it's the same person, not someone with a similar name, before we can immediately cancel. Otherwise, if it comes to us in the form of a sort of a printout or data that appears to be the same person, what that falls into is the category of reliable information that the individual has changed residency out of state rather than an authorization to cancel. And in that case, we inactivate them, but they don't get canceled until 2 federal elections pass, unless they tell us they want to be canceled. There is a method where an individual citizen can also challenge registration, but that has to be done before the individual's clerk. And it has to be with a signed, notarized affidavit that indicates why they believe the person's not qualified. So I agree with Mr. Travilcock that there is definitely a difference between whether someone is registered to vote here and whether they're at this moment a qualified elector. I don't think we have any practical ability, though, to screen the qualified elector question in real time. Whether the board can make that factual determination or whether it have to be a court is not something I can answer for you. I can defer to Eric, who can do his best to summarize what we have on that.
If I could buy Mr. Grill a little more time, if you want.
I think if there would be, I think, a subtle distinction if there were a situation where it was clear that the individual submitting the petition was not in fact a registered voter. That if the staff had conducted an investigation and determined that they're not in the QVF, that might be one thing. But the situation we have here is that the individual is in the QVF and the request is basically for this board to determine that that is incorrect. And that's where I think we have, the gray zone, and the problem here is what is the authority for the board to countermand or override that determination. There is a statutory process for determining whether or not an individual should not be an eligible voter. I think that's usually handled by the local clerk's offices.
If I can make 2 points. One is the Bureau of Elections has had this information for 2 days, and Mr. Brader just said that, when they get information, they can contact the other states' register of electors and see the card and request that stuff. I'd suggest that should happen, and perhaps it has happened. I don't know, but perhaps it should have happened respectfully. And I would say second, determinations on residency happen all the time when you challenge whether or not somebody's qualified to run in a certain office. That gets challenged and determined at the trial court level all the time. In this case, this board is serving as a quasi trial court. And if the decision you reach is wrong, Mr. Bossi has the ability to appeal your decision to the Court of Claims or the Court of Appeals, just like a determination at the trial court. So I would argue that we have provided sufficient evidence for this board to conclude, based on the evidence, that Mr. Bossi is not a qualified elector based on his residence being in California.
There is, I'm sorry.
Mr. Grill, you had.
It does occur to me that there is a problem with that if this board were to make that determination that Mr. Bossi is not an actual qualified voter, that doesn't itself have any consequential effects with his registration status in the QVF or his registration with the local clerk's office. There would still have to be additional steps taken for that registration status to be changed. So it presents at least the problem that this board's determination would be in conflict with state records.
Mr. Housekeep?
I guess, I listen to all your arguments, but I have one underlying piece here, and that is that to go with what you're saying, in effect, you're turning this board into an investigative unit against somebody who's a voter in the state of Michigan. And I get really, that to me would be reason to not go with your argument. Because if we go with your argument, in effect, what happens is that means anybody that comes to us with a petition or anybody that comes to us with business to conduct, you're opening up a door where we can now start to investigate that individual to see whether they're worthy to even come in here. And I think that that's not our mission.
I think in the standards here, you are the gatekeepers of access to the ballot, and the Constitution sets those standards. And working with the Bureau, we have deadlines as parties challenging the petition, both the content and the ability to assert such a petition, that we submitted evidence to the Bureau 2-3 days ago that says this individual is registered in California and shouldn't be eligible to submit this. So that is a very ministerial function to verify and request that documentation and look at it. It's like comparing signatures. This board has the authority, and matter of fact, required to compare signatures many times in various parts of the statute. So I don't think it's opening the door. Rather, I think the floodgate you're opening is that every Tom, Dick, and Harry across this country that's got a beef with some Michigan election official is going to flood this board with recall petitions.
I don't think we have a lot of Tom, Dick, and Harrys who are registered in other states who are filing petitions to recall Michigan officials. I
We shall see.
understand, you can say that, and Mr. Bazzi may be inclined to continue this effort, which is not going to restore his driver's license. He concedes that. His driver's license was revoked because of a number of driving under the influence infractions for which he was also imprisoned. Mr. Bazzi is a problematic character, but I don't think that we have the authority to say that he is not able to file a recall petition. He may intend to return to Michigan, in which case people can temporarily relocate. And I understand that he registered to vote in Michigan, or excuse me, in California. People can temporarily relocate to another jurisdiction with intention to return, and then they're still eligible if they do in fact return or even seek an absentee ballot. So let me just
during
say,
that
Mr.
period of time,
Trubelcock,
you can still
you are-
submit recall petitions?
You are a
in the state of
wonderful
California?
advocate, but we have a very long agenda, so I think it's time
All
to
right.
call the question.
If you wanted to take that argument, save it for one that comes in that's got a little more walls to it.
Right.
I know what you've submitted, and I know.
I don't
the
avoid
documents.
difficult questions. And I think I understand that this is something new and different that this board hasn't faced before, but it is the right conclusion. And I would urge you to follow that right conclusion.
And I think that Mr. Hauskamp is correct, that we don't need to reach this difficult issue because we can reject the petition on an easier ground. And he is correct that if Mr. Bazzi comes back with something that appears to be clear, if he's capable of doing that, then we might then face the issue which you're raising. Did you want to make a motion?
I believe that I'm much more firmly in line with Mr. Trubelcock's thinking. And I don't want to make a futile motion when we have, I think, unanimous agreement on the factual and clarity issue. And so I don't know as making a motion from me makes the most sense.
Do we have a motion on the issue of clarity? Which is properly before us?
Trying to get my words here, because when we first started doing recalls, you could just say that it wasn't factual and it wasn't clear. And
Sorry.
oh, it's okay. I've been here long enough that you are correct that the last thing that you just brought to us is new. And having been here for 10 years, yes, constantly. So for this, this one, I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Chad Bossy against Governor Gretchen Whitmer on January 2nd, 2024 are not factual and sufficiently clear because it does not state when the budget happened. There's a couple, and goes to opinion and not fact.
Motion has been made and seconded. All in favor?
Aye.
Motion carries, and the petition to recall Governor Whitmer is rejected.
Thank you. And
We'll
thank you for
probably see
entertaining
you
my legal
again,
arguments.
Mr. Bilcock. Mr. Bossy wants to give you a lot of work.
Sorry, Madam Chair, may I ask just a question? So, and I think that, just going back to when when we started these petitions, we were, not really all of them, but I'm thinking back to the ones from Mr. Bossy. We were under the rule for, under remote, right?
Mm.
So Mr. Bossy has the right and can send his comments via email to the Bureau, correct?
Yes.
Okay, so he could have stated, however, his case instead of just sending us a email of that he's a registered voter in the state of Michigan.
Yes.
Okay, I just wanted to make sure that I know we have to talk about this the next time because we have another one. But the other question I have for Director Brader is if the Bureau, after someone submits a recall petition, finds that individual after the time that the petition is submitted to the Bureau before, and remind everyone, what is the time frame that we have to meet after a recall petition is submitted?
10 to 20 days.
10 to 20 days. If the Bureau finds in that 10 to 20 days that individual isn't a qualified elector, the Bureau would pull those petitions, or what would be the process?
I don't think we wouldn't put it on the agenda. I don't think we've had that happen since the clarity and factual statute was passed, at least not in my time. Have we? Maybe I'm wrong. Well, in any case, the answer is we wouldn't put it on the agenda. We would notify the board, but we wouldn't put it on the agenda.
Thank you. Okay, the next item on the agenda is consideration of the sufficiency of the recall petition submitted by Chad Bossy against Secretary of State Jocelyn Benson. The petition reads as follows. Michigan Secretary of State Jocelyn Benson, in her current term, has enforced MCL 257.904, even though it has similar effects to slave licensing that put restrictions on movement, acts to create subordination, and has potential for abuse. It likewise is similar to black codes due to vagueness, discriminatory application, and chilling effects on speech and conduct. Also similar to Jim Crow laws, as it creates an environment of economic discrimination, disenfranchisement, and social control. And another reason, separate reason, Jocelyn Benson procures half Michigan license plates sold with laborers paid 45 cents per hour. And for information purposes for people here, I would add that MCL 257.904 is the motor vehicle code. Jeffrey Aronoff has asked to speak to this issue.
Better?
Okay.
Okay.
Got it.
I'll try to keep this very short. You have our letter. I'm Jeff Aronoff from Miller Canfield on behalf of Secretary Benson. And seeing that you found the prior submission by Mr. Bossi for the recall for the governor to be not factual or clear, and significant overlap in terms of there being statements rife with opinion and kind of these editorial connections. I'm not going to go into much detail in our arguments at all. I will make one distinguishing note between this and the prior recall petition that was considered. As Madam Chair pointed out, this is the motor vehicle code, specifically the provisions relating to operating without an operator's or chauffeur's license or an unregistered vehicle. And in Mr. Bossi's submission, he makes no reference whatsoever to the content of that statutory provision, and instead makes those statements, as Madam Chair read, related to ill-defined and highly inflammatory concepts in American history and law. So I think I will leave it at that and ask if you have any questions.
Do we have any questions for Mr. Aronoff? Do we have a motion?
I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Chad E. Bossi against Secretary of State Jocelyn Benson on January 2nd, 2024 are not factual and sufficiently clear because they don't establish fact. Their conjecture, their opinion.
I'll second that.
All in favor?
Aye.
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 Motion carries. Thank you, Mr. Aronoff. The next item on the agenda is a motion to recall Attorney General Dana Nessel. The reason printed on the petition by this is by Mr. Chad Bossi. This is Michigan Attorney General Dana Nessel has failed to protect the citizens of Michigan by allowing vague and discriminatory statutes that have similarities to slave licenses, Black Code, and Jim Crow laws, but disproportionately affect people with disabilities, low-income individuals, communities, and areas with poor public transportation options. The Attorney General has neglected to enforce the separation of powers clause, as the executive branch has multiple offices that perform executive branch, legislative, and judicial functions, acting as prosecutor and adjudicator. Mr. Liedl has requested to speak to this issue, and Mr. Liedl has presented us with a very extensive position letter.
Thank you, Madam Chair and members. I won't rehash the lengthy letter. I do want to note a couple of things. First, because this issue actually also affects my client, I do want to reiterate that I do agree with the arguments, the legal arguments that you heard from Mr. Trubilcock about the eligibility of Mr. Bossi to even seek to recall a statewide official in Michigan. I want to share my thoughts. I'll keep them brief on this. I think I can add some distinctions to what you heard from Mr. Trubilcock. Under Michigan law, our Constitution and election law, it's clear who can recall a statewide official. Well, someone who is registered, qualified, and resides in the state. This board has information indicating that Mr. Bossi is not registered, qualified, and residing in the state. Mr. Trubilcock is a member of the bar and officer of the court. He submitted documentation to your staff at the Bureau of Elections indicating that Mr. Bossi indeed resides in California and is registered there. I don't believe you're permitted to be registered. You may be permitted to be registered, but I don't believe you're actually authorized to perform the functions of a registered and qualified elector in multiple states at the same time. And this concerns me with regard to the integrity of our election process. And I'm not an election conspiracy theorist. I mean, if Mr. Bossie had never been a resident of Michigan and never registered to vote in here, what would this board and this bureau do? You would not process the recall petition. The recall petition would be a nullity under Michigan law because it wasn't submitted by a registered and qualified elector of this state who resides in this state. Okay, well, let's say Mr. Bossie has been, but since the time he submitted, he's dead. Okay, well, he may be on the voter registration rolls, but he's not a qualified voter, and he may be interred in this state, but he doesn't reside in this state. That petition should be a nullity. We permit voters in this state to register at 17, even though they may not yet be qualified electors. So you could have a situation where someone appears as a registered voter, and the process that your elections director described would forward that recall petition to you because they're, quote, registered. They're not qualified to recall anyone in that circumstance. So to assure that the Bureau and the board are complying with the law and assuring that you are exercising your duty to faithfully enforce the Constitution and the election law, it requires action beyond just simply determining whether someone who may appear on the registration rolls. And that's my concern with the chair's legal argument that she presented. Yes, Mr. Bossie may be registered here, but there appears to be evidence that he is registered in California and elected in California. Well, does that mean in addition to taking this function as a registered and qualified elector in recalling a state official, he can do others? We have a presidential primary pending. He's on the voter rolls. Are we going to permit Mr. Bossie to vote in the Michigan presidential primary? We also does the same in California. The inquiry really should go beyond whether someone's currently appears on the voter registration rolls. That is not enough to determine whether or not a petition submitted by an individual meets the constitutional and legal requirements. And so it's my position in this instance that the petition submitted by Mr. Bossie does not appear to be. Otherwise, you could have a situation for multiple years where he can continue to submit petitions here because he appears on the voter rolls, even though he may not be qualified. He can do the same thing in California or any other state that he may move to. Sure, we have folks that register and may temporarily reside somewhere else. And my parents reside in Florida from January to April. They don't register to vote in Florida. They may not agree with Governor DeSantis, but they have no legal authority to seek his recall in Florida. And they maintain their voter registration here. That does not appear to be the case with Mr. Bossie, who appears to have permanently moved and registered in another state. So I would urge both the board to reconsider its position in this instance. I think you have to look beyond whether or not someone is merely registered. Because if someone is registered but not qualified and residing in the state, the matter before you is a nullity. What you have done in acting upon Mr. Bossie's petitions to seeking to recall the governor and the secretary of state is confirm that you do believe it is a valid recall petition because you've taken the next step to determine whether the reasons for recall are of sufficient clarity and factual. So that's my legal concern. That's my disagreement with the chair's argument. I would urge the board to do so. I would also urge, for the sake of the integrity of our voter rolls, that when the Bureau of Elections has clear indication from the officer of a court that someone is not registered to vote, that the Bureau is pretty proactive in inquiring with the other state to prevent someone like Mr. Bossie from taking the full actions of a registered elector and potentially even voting in a primary election. We have a presidential primary election occurring now. Those are my concerns as a lawyer on this matter. And I'll move on to the,
And I need to respond to some of the insinuations that are being made about our election system, with all due respect to Mr. Lidl. First of all, if indeed Mr. Bazzi ends up not being a qualified elector for purposes of submitting this recall petition, there is legal recourse, even if it's not within this board, that a concerned individual could take. Regarding the suggestion that someone could vote in multiple states without consequences, that's simply not the case. When you vote, you create a permanent record that you have voted. So if Mr. Bazzi or anyone else who's not a qualified elector signs an application to vote indicating under penalty of perjury that they're eligible to vote in Michigan and they are not, they can be prosecuted, and people have been prosecuted for this in Michigan and other states. There is a suggestion that the Bureau of Elections is not proactive when it receives information about potentially ineligible voters. That's not accurate. And it does not matter, with all due respect to lawyers. Doesn't matter whether the person raising the information is a lawyer. It matters where the information came from. Namely, did it come from an election authority, or did it come from an individual voter, or did it come from another individual who is neither one of those things? Our election law, which we are bound to follow, indicates that when an individual believes that another individual is not registered to vote, the way that information is presented is to the clerk of the jurisdiction, not to the Bureau of Elections. So section 512, 168.512 specifies that if an individual believes that another individual is not qualified, an individual of that jurisdiction, in this case, Albion, could go to the clerk, not say they appear to not live here, but actually say, I am swearing in this notarized affidavit that this person is not a resident, and here's why. So that's the process to follow if you believe that another elector is not eligible. In terms of what the state does, the state's role in maintaining our voter list is not individualized challenges. As noted, those are handled by the clerks. Rather, what we do is a much more efficient, large-scale list maintenance effort by which we get information about voters who have registered in other states on lists. Again, as I explained before, when there is a large list of voters with names, not signatures, we follow the National Voter Registration Act process. We also utilize surrender driver's licenses out of state on a systematic level. And we also, along with clerks, utilize returned election mail to maintain the voter list. If you go to michigan.gov/vote, you can read all about the process by which we identify these voters. There's about 500,000 people right now who are registered to vote who've been identified through this process and who will be canceled in accordance with state and federal law. But if an individual wants something to move faster and they believe that another individual in their jurisdiction should be canceled more quickly, they can follow the process under 512.
Thank you. That's very helpful.
Yep. Respectfully, with regard to the director's statement, my argument was not that this would permit Mr. Bazzi to vote in 2 states. My argument was that because someone is registered to vote, that does not mean that they should be permitted to then take other actions that are limited to qualified electors who are not, that are also residents of the state. Clearly, we have in this instance, and this is where Mr. Bazzi, he may appear on the registration rolls. The procedures under federal law may not permit him to be immediately removed from the registration rolls. But that doesn't mean he can take other actions as a qualified elector who resides in this state. He can't vote. He can't sign nominating petitions. He couldn't sign the recall petition itself legally under Michigan law, even though he appears on the voter registration rolls. He couldn't take other functions that registered voters in the state may take. Why is it that is he being allowed to take an action that is limited under state law only to qualified and registered electors? And I understand the procedures and the responsibilities of state and local elected officials. My concern as an attorney, when the State Bureau of Elections has information that pretty clearly indicates from a reliable source who can't provide incorrect information to the Bureau under the rules of professional conduct, that instead of relying upon federal procedures and saying that's someone else's responsibility, pick up the phone and call the local clerk. sending information to the local clerk, confirm the information with another state so that we don't have any questions about whether someone who is not permitted to take action as a qualified elector residing in the state is somehow permitted under state law to take action as a qualified elector and resident of the state. With that, I'll move to the reasons for recall included in the petition. The position of the Bureau and the board appears clear on this issue. The reasons for recall should be rejected because they're not factual or stated in a factual manner. There's a lot of conjecture or personal opinion that does not constitute facts under the election law or the relevant case law. The reasons for recall submitted against the Attorney General also aren't sufficiently clear. They failed to clearly identify the conduct of the Attorney General, not conduct by others, that are the basis for the recall. And then lastly, by objective measures included in the submission to the board by various educational and scientific measures, the proposed recall language is not readable. It's not clear by all measures. And for those reasons, I'd ask the board to reject this recall provision and would be happy to answer any questions.
Any questions for Mr. Polito? We have a motion.
Do this one, but stating that I still remain convinced that Mr. Bassi is not a qualified elector and that accepting these is as eligible is a mistake that I think we probably will be coming back to at some point.
Member Don, do you mind if I ask a question before you make that motion?
Sure.
Okay. This is to the chair and the bureau director. Would it be ruled out of order for us to make a motion to investigate the status of Mr. Bassi? I'm not making it, I'm asking. Would it be ruled out of order for us to, as a board, given the documents that we've been given today, would that be ruled out of order? And I guess I should look at our legal representation as well.
Mr. Grill?
I think I would need some time to look into the question of whether it is out of order or not. I do know in general, the board's investigatory capacities are somewhat restricted. I think that would be something I would also have to look into in further detail.
Just asking the question.
Mr. Grill has answered the question.
It's fine. Just so that
Okay. Do we have a motion with regard to the clarity of the petition submitted by Mr. Bassi?
Indeed, I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Chad E. Bassi against Attorney General Dana Nessel on January 2nd, 2024 are not factual and sufficiently clear because it is rife with opinion and conjecture and does not meet the standards for factual or sufficiently clear.
I will support that motion.
All in favor?
Aye.
Motion carries, and the petition to recall Attorney General Nessel is rejected.
Can we take a short recess?
Okay. Yeah, it is 11:15. We've been in session for an hour and a quarter. We're going to take a 5-minute, well, maybe 10-minute recess. Knowing how recesses always extend. Mike, okay. The next item on the agenda is consideration of the 100-word summary of the purpose of the constitutional amendment sponsored by Axe My Tax. The summary as drafted by the Director of Elections is as follows. Constitutional amendment to prohibit real property taxes and alternative means of taxation on real or personal property, require 60% of voters to approve local taxes, require 2/3 vote of legislature to increase any state tax by more than 0.1%, increase percentage of state sales tax revenue that is distributed to local governments instead of the state to 20% for municipalities and 10% for counties, shift 10% of income, marijuana, alcohol, and tobacco tax revenue from state to local governments, require that tax revenue distributed to local governments be used only for public safety, law enforcement, courts, emergency response, and essential infrastructure, require legislation implementing these requirements. We have a number of people who have asked to speak to this. I would first call the people who are opposed to this summary, and then we'll hear from Mr. McCord in favor of the summary. So first, Mr. Brewer.
Hacker on behalf of Michiganders for the Commonwealth. And we are legal counsel for that organization, which opposes not only this petition, but this proposed petition summary. Thank you. Sorry. This is the third time this group has been before the board seeking approval of its summary, and most emphatically, the third time is not the charm. The summary before you varies little from the summary that was not approved the last time they were here, and it still suffers the same defects. We submitted a letter noting our objections and mindful of the chair's admonition to be brief. I will be brief. First, this board in the past has required that a petition like this, a constitutional amendment petition, have a complete list of all the provisions altered or abrogated by the constitutional proposal. This petition continues to fall well short. They've added a few provisions of the Constitution, which would be abrogated by this. But as we point out in our letter, there are at least two more, and I believe there are probably a score more that they have not added. It's impossible for the director to write a summary unless he has a complete petition that lists accurately all of those abrogated provisions. So you're not even in a position, frankly, to review or approve a summary because the director has been handicapped by the fact that the petitioners have failed to make the full disclosure of all the altered or abrogated provisions. So that's one objection. The second one that we also indicate, and we have relied upon in the past, is that this board has repeatedly required that summaries for petitions disclose the effects of a petition, and both in our letter and in others submitted by people who oppose this proposal, there is no disclosure of the enormous adverse financial consequences of this proposal. Just to briefly reiterate what we cite in our letter, this proposal appears to eliminate at least $3 billion in funding for public education with no replacement revenue. There's no disclosure of that. People are asked to sign this, are entitled to know that. In addition, property taxes are a significant source of revenue for local governments in this state to the tune of billions and billions of dollars. There is no indication in the summary that that revenue would be eliminated without adequate replacement. So the summary is not only inadequate and frankly shouldn't even be before you because it does not deal with the altered and abrogated provisions, but also because it does not honestly disclose to signers these very significant financial consequences. So for those reasons, we'd ask the board to reject for the third time and send this group back to the drawing board to provide you with a complete petition and an accurate summary. With that, I'll be glad to take any questions.
Questions for Mr. Brewer?
Nothing? Thank you very much.
Okay, Ms. Flower? Mr. Lidl?
Thank you again, Madam Chair and members. I'll be addressing agenda item number 6. And my colleague Olivia Flower will be addressing agenda item number 7. So with regard to the summary prepared by the director consistent with the election law for consideration by the board, I'll remind the board of the standard. Can't exceed 100 words. It's supposed to be under the statute a summary of the purpose and consists of a true and impartial statement of the purpose of the proposed amendment. I think you have a summary before you, and the director's summaries are usually quite good, but in this one, I think it's inaccurate and incomplete, and it does attempt to, in my opinion, to summarize the content of some of the proposal, but it doesn't address the purpose of the proposal. So what's the purpose of this proposal? As the statute requires you to consider, I think it's pretty clear. In 2001, Grover Norquist, the founder and president of Americans for Tax Reform, told National Public Radio, "I don't want to abolish government, quote. I simply want to reduce it to the size where I can drag it into the bathroom and drown it in the bathtub." So at its essence, at its core, that's the purpose of this proposed constitutional amendment. According to the Nonpartisan Citizens Research Council of Michigan, in 2022, local property taxes generated more than $15 billion, including $7.6 billion to pay for schools for our children. But this proposal eliminates property taxes and fails to replace the money that funds vital services. Most school districts, community colleges, and other local units of government lack the legal authority to levy any tax other than a property tax, which would be prohibited by this proposal, and they have no legal ability to generate permanent replacement funding, none. And while the proposal would mandate moving money, or some money, from the state that is used to fund vital state programs like prisons and state police, only some local units of government will qualify to receive replacement revenue under this proposal. By the plain text of this proposal, only counties, townships, and villages and cities would receive the state money transferred under the proposal. School districts get nothing, zero. Community colleges get nothing. Police and fire authorities get nothing. Public transportation authorities, library districts, intermediate school districts, park and recreation districts or authorities, nothing, nada, zero, zilch. Their property tax revenue is eliminated, and no replacement funding is provided in the proposal. And that should be very clear to voters in any summary of the purpose of this proposal. And while cities and counties and townships will get some money, if you look at the numbers from the Citizens Research Council, that's about $3.7 billion that would be transferred from the state general fund each year to local units of government, being cities, villages, townships, and counties. That only constitutes 21.2% of current property tax revenue. So that's less than a quarter of replacement lever for every dollar, but only for cities, counties, villages, and townships. Not at all clear in the summary. In addition, and I'll try and wrap this up briefly, there's an impact on state revenue, which is not at all addressed in this proposal. The impact on state programs is not addressed in the summary. The proposal eliminates the state education tax. That's a state property tax on real property. $2.3 billion that generated in 2022, or the fiscal year ending in 2021, the state fiscal year. The proposal provides zero replacement for this money for state aid to school districts. Because the proposal transfers $3.7 billion annually to cities, villages, townships, and counties, that means it's a 21.2% reduction in the state general fund. That means that this proposal, and it takes effect if it's approved by voters in December of 2024, immediately, it results in a 21.2% cut for state prisons, state police, prosecutors, courts, the Bureau of Elections, and all other state activities funded with general fund dollars. None of this is addressed in the summary or even hinted at in the summary, but it's the purpose of the proposal. Then the proposal goes further, severely restricting or rendering it basically effectively impossible for state and local government to raise replacement funding. Alternative taxes on real and personal property are prohibited by the proposal. For a local unit of government, including schools, to raise any replacement tax, if they even have any authority to levy a tax other than a property tax in the first place, approval by a supermajority, 60% of voters, is required to approve any proposed amendment. That empowers a minority of voters to make financial decisions for their communities. For state government, approval by a supermajority, 2/3, again, minority rule, would be required for any change of a tax law that increases state revenues by more than 0.1% over 5 years. That's the purpose of this proposal. And Michigan election law requires the purpose of the proposal to be summarized in a summary. It's not, doesn't comply with the statute for that reason and should be rejected. I will also note briefly some of these items which were touched upon in my prior correspondence, some not. The proposal fails to indicate that the proposal eliminates the constitutional requirement protecting taxpayers that all property taxes be assessed uniformly. Personal property taxes would continue to be taxed. They're not prohibited under this proposal. And that would mean that someone who lived in, let's say, Mr. Daunt's neighborhood, 3 streets over, could pay a different rate on his personal property than Mr. Daunt would pay. Currently, taxes have to be assessed uniformly under the Constitution. That's in the proposal. It's part of the purpose of the proposal. It's nowhere to be found in the summary. Similarly, the constitutional requirement that protects taxpayers that property taxes cannot be assessed at more than 50% of true cash value, abolished, eliminated by their proposed constitutional amendment. No notice to voters of this protection being removed in the summary. Lastly, similarly, the requirement that the values of properties be equalized to avoid unfair treatment to property taxpayers, also abolished. I think it's also significant to note that there's an existing exemption from property taxes that is abolished, repealed, eliminated by this proposal. Currently, our Constitution says that property of nonprofit, religious, and educational institutions are exempt from taxation. That means personal property that a church holds, let's say Bibles, church pews, vestments, chalices, that's all personal property. Currently, Michigan's Constitution protects that property from taxation, prohibits taxation of this property. This proposal eliminates that protection for religious and nonprofit educational exemptions. I believe voters have a right to know that. That is not included in the summary. 2 last items that are problematic in the summary. The summary indicates that the proposal would require a 2/3 vote to increase any tax by more than 0.1%. That's not accurate. It's therefore not true and impartial as required by the election law. What the language of the proposal actually requires, it's not that a tax is increased by more than 0.1%. It's that if the legislature changes a tax law and the result of that change increases state revenue by more than 0.1% over 5 years, there must be a 2/3 vote of the legislature. That is very different than what is summarized in the proposal. Again, not accurate. Lastly, the summary suggests that this revenue would be transferred from the state to local governments. Again, not true. It suggests that all local governments would receive some of this money. Not true, not accurate. It creates a bias or a prejudice in favor of approving this proposal because of that. In actuality, what the proposal actually does is provide the transfer of some revenue to counties, cities, villages, and townships. But it doesn't provide any revenue transfers for school districts, intermediate school districts, community colleges, police and fire authorities, parks and recreation authorities, library districts, and numerous other local government authorities that provide vital services and would receive zero state revenue under the plain language of the proposal. These are all items that my client, the Citizens to Protect and Save Public Safety and Schools, believe should be included in the summary. They're not. And for those reasons, we urge the board to reject the summary that has been presented to you, and we'll be happy to answer any questions.
Questions from Mr. Lito?
Mr. Ladle, it's always great to see you.
Thanks. Good to see you.
When you started your conversation, your first point was that this 100-word summary doesn't provide a purpose. It doesn't say what it is, but it does. I mean, to me, prohibit real property taxes and alternative means of taxation on real or personal property. Even if I stop at the semicolon, that seems to me to be a pretty concise statement of purpose.
If that were all the proposal did, I would agree with you, Member Hauskamp, but the proposal doesn't stop there, right? And again, the statute does not direct an inventory of the content of the proposal. It directs a summary of the purpose of the proposal. I believe the legislature recognized that there are many instances where a summary of the content would be too exhaustive to satisfy the legislature's 100-word requirement, right? So the purpose is beyond just prohibit future levies of real property taxes and alternatives to taxes on real and personal properties. It goes on and on and on from there, right? It severely restricts the ability of local units to raise replacement revenue. It severely reduces state general fund revenue immediately and restricts both local units, many of which have no legal authority to replace that revenue, from doing so. So the purpose is beyond just prohibiting the levy of property taxes. It is one to prevent any sort of replacement revenue, to provide no replacement revenue for schools, community colleges, and other entities, essentially to prevent them from functioning. That is the result. And I think the legislature also, provided a purpose so that the summaries sometimes, as Mr. Brewer has suggested, indicate the impact of the proposal. For example, when Proposal A was adopted in 1994, the summary for the ballot prepared by the Director of Elections indicated that if the proposal wasn't adopted, income taxes would be increased to a certain rate. You would not find that in the words of the proposal before the board and the Director of Elections. But that was part of the purpose. Adopt this or the state will increase your income taxes. So in my view, there are other elements of this proposal. If the proposal stopped with its changes to the first section of the Constitution, and that's all this proposal would do, it would be an accurate summary of the purpose. It was only to prevent the levy in the future of taxes on real property and alternatives. But it does much more. And those broader purposes, in my view, you have a statutory mandate to reflect those purposes in the content of the summary under the election law.
Thank you.
Yeah, I'm looking again. It always helps to look at the statute.
Mhm.
The summary is limited to not more than 100 words and must consist of a true and impartial statement of the purpose. In language that does not create prejudice for or against the proposed amendment or question proposed. It seems to me that it's at least arguable, and I think you've argued this, that if you don't have some summary of the effects of the proposal, the really cataclysmic effects of the proposal, that one then does create prejudice in favor of the proposal, because it suggests the proposal, the language drafted by Director Brader suggests that it tells people that their property taxes are going to be eliminated, but that money will be redirected. But it doesn't tell people, and everybody says, oh, that's good. And nobody can figure out what 20% of this and 30% of that and 10% of the other, what that's going to do. And therefore, it seems to me that without some identification of the effects, that the summary creates prejudice in favor of the proposal. Would you address?
Yeah,
that?
I think, thank you, Madam Chair. I agree with you. I think you correctly read the text. I would note that, before you get to the listed items, there's a second reference that, you're supposed to be presented a summary of the purpose, right? And you can't understand the purpose unless you understand the effects clearly. I think what's most troubling to me is, if we were to say in simple words, let's tell you from the perspective of, many taxpayers, all the good things that this proposal does. Well, it eliminates property tax. Well, you won't have to pay them anymore as a taxpayer. That's good for you as a taxpayer, right? Let's tell them that. We tell them that in the summary. Oh, let's tell them that the legislature can't increase a tax by more than 1.1%. I mean, sounds pretty good. No more tax increases from the state legislature, even though that's actually, as I indicated, not accurate. Doesn't accurately describe what the proposal does. But that's kind of a good thing if you're a taxpayer and you say, hey, I'd rather not pay taxes. I mean, taxes are the costs we pay for a civilized society, but I think a lot of us, if not all of us, would prefer not to pay them. And then lastly, on that, I guess it's a good thing from the perspective of a taxpayer that there be some replacement revenue provided. But the problem with that is, oh, good, but it doesn't give you the quality, of that replacement, right? Like, okay, I'm going to take away your lunches, your school lunches for the next year, and I'm going to replace them. You get 1p, right? That's not a lunch replacement. And I think that's a problem with it. And I think lastly, as you suggest, there's a lot of good things from the perspective of a taxpayer, for whatever reason, doesn't want to, is struggling with financial difficulties, tight family budgets. They may not want to pay taxes. Lots of good things in there from that perspective. What about the bad things? Oh, your kids' schools won't have any money. Oh, the police and fire authority down the street from you that comes to put out the fire that may break out in your house because of a lightning strike or for some other reason. Guess what? They have no legal authority to levy any tax, to pay the firefighters, to put gas in the fire truck, or to buy the equipment. And there's nothing under state law that allows them to replace it. And so those are some bad things about this proposal, right? And how do you not create prejudice in favor of the proposal if you only talk from the perspective of certain taxpayers about the good things, and you don't also tell them some of the bad consequences, some of them very bad, for all residents of this state of this proposal? And that's why, in my view, this is not an impartial summary. It does create prejudice in its current form in favor of the proponents of this proposed constitutional amendment, and why I think you have a duty as a board to reject this proposal.
It's just a comment. And again, I'm the newbie here, right? I'm the one that just joined. But even in the year and a half that I've been here, it seems like I've seen a lot of proposals that have come to us with 100-word summaries that would meet the bill for exactly what you're arguing we should turn down. I've seen a lot of proposals that have come up that present the benefits of the proposal through the eyes of the petitioner that don't deal with the potential negative fallout. And you know that because you've represented the opposing side of some of those. You've represented the side that's saying we need this petition. How would you, there's 100 words here. What line, you've got really short amounts of space to put something in. What line would you put in?
All right. Well, in my January 12th letter to the board, I hope that was shared with you in a timely manner. It was emailed to your email address as a board. I did attach a proposed summary that I believe would do a better job of addressing these things. I think, remember, you mentioned the past examples. In those instances, you got to.
Which is an open sesame right now is exactly what I'm giving you is an open sesame to
Right.
read that 100-word
Yeah.
summary.
So, folks agreed, in those instances, you were references on both sides as to what was a fair and impartial summary, and both sides agreed that what was initially presented by the director wasn't. So here is what I would propose. You could do some other things, but it's a constitutional amendment, and this is in 100 words, to prohibit state and local property taxes on real property. It does that. Eliminate for personal property taxes requirements for uniform assessment of 50% of true cash value and exemption for religious and educational institutions. Require 60% of voters to approve local taxes and 2/3 of legislature to increase, let's say, state tax revenue. State revenue to transfer portions of state taxes on sales, income, marijuana, alcohol beverages, and tobacco products to counties, townships, villages, and cities only for restricted uses. Provide schools, community college, and other local units of government no replacement revenue for real property tax revenue eliminated, and require legislation implementing these requirements. In my view, that's a much fairer and impartial 100-word summary that satisfies the requirements of the election law.
Thank you for reading that.
Thank you.
Any other questions for Mr. Lidl?
Thank you.
Mr. McCord?
Morning, Paul McCord on behalf.
Morning.
Good morning, Paul McCord on behalf of Act My Tax. We're here in support of the director's 100-word summary. We found that it was a fair and impartial summary of the proposed amendments. Now, for a number of arguments this morning that it fails because it does not discuss the effects of that. And it's clear that the opponents are more want to argue about the policy of the proposal than actually what it actually says on the document. It is not for this board. You can all disagree with the policy. There might be many people in this room that disagree with the policy, but disagreement over the policy is not for us in this room today to decide. Whether the voters, either in collecting signatures, disagree with the policy, or maybe they might agree with the policy. If it makes it to the ballot, again, the voters will have another chance to agree or disagree with your policy and debate the questions that the opponents have presented. But as far as the document, the summary that the director prepared, we think it is a fair, unbiased position of what has been proposed. In fact, Mr. Lidl's January 12th summary, which he submitted to the board, there are aspects of the language that he proposed that made it to the directors. So the director clearly, I don't know, I can't speak for him, he can talk about it, but they clearly considered that public comment and they made some changes to the summary that had been provided, that they'd written on a couple other times. So I think the summary is fine as it stands. Now, as far as effects, I mean, tons, Mr. Hauskamp is absolutely correct. There's lots of these petitions that come forward that might not talk about all of the draconian effects that Mr. Lidl and Mr. Brewer want mentioned. I mean, an example is the constitutional amendment from the 2022 cycle on the reproductive rights. There is no discussion in here as to the effects of that. How many unborn are we going to extinguish by this proposal? How many young people are we going to mutilate as a result of this proposal? I don't see any of that in here, and yet it passed just as well. And I would also agree with Mr. Hauskamp that, it generally is written in maybe a tone. I think it's a rather neutral tone as it's presented, but it tends to have maybe
more on the side of what it is and what it's proposing to do without getting into all of the other draconian effects that feel that they must be mentioned. Again, I don't think the effects are listed in this one or in many others that have all been approved by this board. So in that regard, again, we are, we support the summary as prepared by the director.
John?
Thank you for coming up here and thanks to the other folks who have testified. This is the third time now with this one. I think there have been good faith efforts by your side to address some of the concerns that have been raised. And so, I'm inclined that we find a way to get 100 words that the four of us can agree on. I'm both personally think some of this is, this isn't the way I would do things. So don't have a brief for your side. And I think some of the things that Mr. Liedl and Mr. Brewer have laid out as to the, supposed catastrophic impacts are, overblown in many ways, and the legislature and others will find ways to address some of these issues. That's my way of saying, let's find a way to get 100 words so that we can move this process along. Frankly, in looking at what Mr. Liedl has provided, it seems very similar to what the director has provided. It, in my mind, it addresses the issue of the lack of a replacement without going into the, all the horrors that could follow. I frankly would be inclined for Director Brader to essentially adopt and address some of that language to get us down the road. I'm curious what your any serious objections to that would be.
Yeah, there's a couple objections on that language, and not in wholesale, but there's a couple that he points out that the proposal would eliminate the exemption for charities and churches. It does. Why? Because there is no more property tax. There is nothing to be exempt from. Same with the provisions for proposal A. There is no property tax. There's no assessment. So there's no assessment level that has to be met. Again, those provisions are essentially, as we've learned, abrogated because of the elimination of the tax. You don't have to be exempt from a tax that does not exist anymore. So some of those points, I guess I would probably edit out only because I find them to be a little bit more charged in the sense that because the effect of the eliminating a charitable exemption for churches and schools, it's because there's no more tax. They're not exempt from anything anymore because everybody is now exempt. So I think to a certain degree, I mean, the proposal of itself, it's almost like a self-executing provision in a sense. So I think that language might create more of a bias against than a more neutral statement.
Can I just ask one question about that? Your proposal only eliminates real property taxes, but not personal property taxes. Isn't that correct?
It eliminates both ad valorem tax and ad valorem property and personal property taxes. Yes.
I'm sorry. It explicitly refers to real property taxes, but not personal property taxes.
There are personal property taxes are in section 3 and they are eliminated.
If I could interject, so I looked at this too, and I did adjust the summary to try to account for the structure. And I'll confess, I'm not a constitutional lawyer or a tax lawyer, so I'm not sure what the significance of this distinction is, but it first says that no tax shall be imposed on real property. And then it says neither the state nor any of its subdivisions shall, et cetera, shall enact any laws or ordinances providing for alternative means of taxation of real and personal property. I'm not really sure whether that has a different effect or purpose. And if section 1 had just said no tax shall be imposed on real or personal property, I'm not sure where the room would be to enact any kind of tax on personal property when it says no alternative means of tax can be developed. But the beginning of the summary that I drafted attempted to mirror that structure where it said you can't impose a tax on real property and you can't impose an alternative tax on real or personal. If someone has a view that within that there would be some kind of tax you could impose on personal property that wasn't an alternative tax, that's well beyond my capacity to interpret authoritatively for the state of Michigan, but that's the structure that I was attempting to mirror there.
Director Brader, so you are in fact saying that in your opening before that first semicolon, that this eliminates property taxes and real personal property taxes.
That's how I understand it, but I'm certainly, if there's different views on that, I'm certainly open to that.
I would interpret it as meaning that the taxes that you impose on personal property continue, but alternative taxes on personal property cannot be imposed. I mean, that's what it says.
No, I'm reading that differently though. I'm reading that
No, but
alternatively to real, you also can't tax personal property. Or you can't,
But if that's what Director Brader's attempt to summarize this says, then it's incorrect because the proposal does not eliminate taxes on personal property. They continue unless, I think Mr. Lidl wants to address this, so I would ask him to do so. Tax law is incredibly complicated. And the Michigan Constitution has a lot of provisions on tax law, which are, for most of us, including for most people in the legal profession, they're not easy to understand. But there's a big difference between personal property and real property. And it is only, as I read it, real property taxes that this proposal seeks to eliminate. Mr. Lidl.
Madam Chair,
yeah.
before Mr. Lidl, Mr. McCord, is your intention, are you eliminating personal property or eliminating the ability to use that as an alternative?
No, we're eliminating ad valorem taxes. Ad valorem taxes are imposed on both real and personal property in the state of Michigan. They're all imposed under the same act.
real property and personal
Yes.
property taxes are all gone.
Right. I think, Mr. McCord, I understand that's your intent, and certainly that's what your original proposal attempted to do. If folks from the board recall, you had sort of a hybrid legislative initiative and proposed constitutional amendment where, folks never got to the summary or consideration of summary. But if you did in fact repeal the General Property Tax Act, you would repeal ad valorem taxes on both real property and personal property tax. This does not do that. I'll direct your attention to the actual words of the Axe My Tax proposal. I think it's important to see the language they strike in Article 9, Section 3. Currently, the Constitution says, the legislature shall provide for the uniform general ad valorem taxation of real and tangible personal property not exempt by law. And then it continues on later on to include some language that says the legislature may provide for alternative means of taxation of designated real and tangible personal property in lieu of general ad valorem taxation. Look, I'm legal counsel at the Michigan Association of County Treasurers. I've been involved in legislation amending the General Property Tax Act since my admission at the bar in 1998. I have a pretty good understanding of how it works. And the words here simply do not repeal the current tax or prevent the levy of the current tax under the general property tax on personal property. It says no tax shall be imposed on real property. So the current general ad valorem tax on real property would definitively, under this proposal, be prohibited from the effective date of this constitutional amendment. Notably absent, unlike the words of the current Constitution, are and personal property and tangible personal property. Now, in addition to the general ad valorem tax, and the general ad valorem tax on personal property would continue to apply. There's no prohibition on that under the text that's actually in the proposal before you today. The local tax assessors would be obligated under the general property tax to continue to levy personal property taxes on tangible personal property. Beyond that, state law does provide for exemptions of properties and alternative means of taxing real and personal property. So for example, there may be an industrial facilities tax exemption imposed on a piece of industrial property for economic development purposes, where that property under the general property tax act is exempt from real and personal property taxes, but pays an alternative tax at an alternative rate that's not subject to the uniformity and the 50% of true cash value provisions that apply. Because the personal property tax continues, that's why I believe it's so important to point out to voters that the protections for taxpayers in terms of both uniformity, true cash value, and equalization, and the protections for churches and other religious and nonprofit educational exemptions would be removed for those continued personal property taxes. That's what the language of the proposal before you does. They may have wanted to do something else earlier. They may have intended to do something else earlier, all irrelevant. What do the actual words of the proposal do? And I would note sort of beyond that, their actual words add confusions. Take a look at their proposed language. Take a look at their proposed amendments to Article 9, Finance and Taxation, Section C. It says property taxation repealed in the heading. Well, which is it? Are we amending this section or are we repealing this section? How is a court to interpret that? How is a voter to interpret that? There's actual language that's added, right? And it doesn't include the magic words, real property and either personal property, or real and personal property, or real property and tangible personal property, as our current Constitution does. You cannot read this without reference to the text of the current Constitution. It's real and personal. The language they propose only prohibits taxes from being imposed on real property.
If I may, I apologize for what may seem based on some ignorance or misreading. In that Section 3, am I understanding correctly from Mr. McCord that the contention is through the striking of that language, you are therefore repealing, in addition to the elimination of taxation on real property, striking that other language is in effect repealing and prohibiting the taxation on personal property?
Yeah, that's what we meant to do. Yeah, by striking that language, exactly.
And your contention, Mr. Liedl, your interpretation is that despite striking that, because they haven't stated in the new language that that is prohibited, that they are not prohibiting it.
Yes, Member Dunn, I think, you understand the state constitution, provisions don't exist in a vacuum. The legislative powers generally is vested by the voters, not reserved to the voters in the legislature. And we know from the state constitution that they have plenary power to enact laws on behalf of the people of the state of Michigan, which means they may do anything not prohibited by the Constitution, right? We have a current law that imposes an ad valorem tax on tangible personal property. This isn't repealed by that. And there's nothing that prohibits the legislature or any local unit of government from imposing a personal property tax act. If they had intended to do so, all they had to do was add the words real and personal property, or real property and tangible personal property. And then you would have a clear prohibition in the Constitution of the state. You can't infer prohibitions or restrictions on the legislature where none exist in the text of the Constitution. I'm a textualist. Read the text. See how it's different from the current text. Where is the prohibition on the levy of the current property tax act that the people of the state have enacted through its legislature? In fact, the current General Property Tax Act imposes a duty on the taxing jurisdictions to levy those taxes.
I have some questions for Mr. McCord. How would elections be financed? I don't see anything that would allow cities and townships to run elections.
The provision says that there would be implementing legislation. And that
I'm
would
sorry, what?
implementing legislation, which is a matter that the legislature could decide. The Constitution doesn't have to provide for everything, and it doesn't provide for everything. That level of detail can be provided by the legislature.
So you're saying that even though your proposal would eliminate property taxes for cities and townships, which are used for numerous purposes, including the conduct of elections, that while you eliminate that tax and tell these cities and townships that they can only use their tax, the limited tax revenue, which is then provided to them, 20%, as Mr. Lidl says, that they can only use that essentially for public safety purposes. You're saying that the legislature could override this constitutional amendment by directing that they use money which they don't have?
I can't override the amendment.
Well, you can. That's the point.
What I'm saying is that we put in restrictions because we know that we're asking, what the client is asking to do is going to be a fundamental shift in the way local government and state government are financed. It's a fundamental shift. There is no doubt that it's a fundamental shift. All right. But a lot of times to get tax reform, you have to do a fundamental shift. Proposal A was a fundamental shift. If you recall, Senator Stabenow was the sponsor of the bill in 1993.
Not to her.
That repealed the General
not
Property
to her
Tax
credit,
Act.
but
Which led us, so to get a fundamental shift, I disagree with the Grover Norquist. That was not a consideration in our proposal. But anyway, in order to get a fundamental shift in the way state and local governments are financed, then sometimes it requires a dramatic revision of the law. And that's what they're proposing. The sponsor fully understands that more likely than not, the legislature and the local governments will come up with means to provide local government financing. In fact, there are a lot of methods currently on the books that are not affected by this proposal.
what?
They can specially assess.
What?
They can specially assess. That is, a special assessment is not a property tax.
So you're saying that local governments could make special assessments to fund themselves?
And they do. They currently do.
Okay, I've
So
learned-
all I'm saying is that, again, I mean, without getting into the policy or the what could be done in the future, the means are there in the future. We put some limits on the means to make sure that the intent of the voters, if they pass this, is that you can come up with an alternative means that has to meet certain parameters, but it can't be on property. Okay? Now, what that shape will be, I don't know. That is a question for the legislature to decide, and they can decide that.
But your proposal also limits the ability of jurisdictions to create any other kind of alternative means. They,
Well, it doesn't, it's not an absolute, it is,
it
it
has to be
puts limits,
done-
it puts limits on it.
It has to be done by a 60% majority
Correct,
to try to come up with some way, for example, to fund schools.
correct.
Or the legislature would have to have a 2/3 majority to try to find a way to fund community colleges.
Correct. And 15 other states have similar provisions, and they fund their community colleges and their schools.
So I'm looking at my tax bill. This is Wayne County. So, and it lists the taxing units. So, you know, part of my property tax goes to Wayne County, part of it goes to Detroit. It also goes to the Huron Clinton Metropolitan Authority, which is so they would get no money. Is that correct? They would get nothing.
They would not be funded through the property tax system because there wouldn't be a property tax.
But there would be no other way to fund them either, because the legislature is prohibited from imposing any new taxes.
On real property.
No, period.
No, it's not period.
Require 2/3 vote of legislature to increase any tax,
Correct.
any tax.
That's right.
by
That's not a
more than-
prohibition. It's a limitation on the taxing
Right.
power.
Okay, so okay, so that's.
And that's
so
described in the summary.
So the Huron, if your proposal were were adopted as of January 25th, or I'm sorry, January 1st, 2025, the Huron Clinton Metropolitan Parks Authority would get nothing. Isn't that correct? They would have no money. The Detroit Zoo would have no money.
Well,
The
okay.
DIA would have no money.
Not
that-
a,
Their money, the money that comes from the property
their
tax,
funding source, they wouldn't have no money. The funding source, they'd still probably have fund balances.
I'm sorry, what?
They still have a fund balance on their books.
You mean they might have a little money?
In the bank.
Oh, yeah, right.
In the bank.
So,
Okay, ma'am, you know, what, we're talking about the policy of it, right? And
no,
and
we're talking about
does
what
this,
you yourself called the draconian effects.
well,
so-
no, that was not I was characterizing my opponents.
Do
You
you
were the
think
one.
it's a draconian effect to eliminate 40% of community college funding?
I have no opinion on that.
Do you think that people who are asked to sign this petition should understand that that is what they would be seeking to put on the ballot?
I don't know what other people would understand or not understand. I know that a lot of people, when this proposal is discussed, they raise some of the same questions that you have raised and that the objectors have raised as to whether or not they would be willing to sign such a thing. I don't think it's hidden in the summary as to what this proposal may do. And I think people can evaluate that on their own.
Okay, so I read your proposal, this is several meetings ago. And I looked, I pulled up as well as I could, information about where the money comes from and where it goes. And tried to calculate how much of this 20% of this and 10% of that going this way and that way, how much of it would amount to. And it amounts to, and Mr. Lidl obviously did the same thing. So you're taking away a substantial amount of money and you're replacing it with 20% as much, which you take from the state. Isn't that something that ought to be disclosed to people who are asking whether they want to make this fundamental shift in the financing of state and local government?
Well, the director's summary does talk about the shift,
But
the
you- but
20%.
It provides absolutely no information about what that shift would mean for
Again,
local
that,
governments.
okay, then we're just having this debate that we're not going to agree on as to whether or not the effects have to be, certain effects have to be in the summary. You only have 100 words to mention this.
If I can interject, Madam Chair,
Yes.
I understand your concerns from your perspective on what this could do to the various elements. But that is very much a policy as well as an issue that the two sides fight out in the court of public opinion. And we simply can't address that 85 different entities are going to have their taxes based on this, their tax revenue reduced. And that's why, Mr. Lidl a very strong opponent to this for, I'm sure for the reasons that you are laying out. Again, this isn't how I would do it. I have fears that there will be alternative methods of taxation that end up being worse. But Mr. Lidl's provided something that meets the requirements of 100 words, that from their perspective addresses some of these concerns, that matches this very similar to what Director Brader has put out. You know, we can continue having a debate on the impact of this, but I think as a body, we probably should decide, are we gonna try to come up with 100 words or are we not?
With all due respect to Mr. Lidl, I don't think that his proposed summary is adequate at all. I don't think that what I think the summary needs to do is, and we've discussed this in prior discussions about other ballot proposals. I think it needs to give the public, the people whose signature on this petition is being solicited, enough information so that they can decide this is something I support or it isn't. We need to give them adequate information to make an informed decision. And I think that requires something about, okay, this takes away, almost all of the revenue of state, of city and township governments, and replaces it with about 20% taken from the state. I think that those numbers, and probably not just percentages, but numbers need to be there so people can recognize that this is the purpose and effect. I think that the effect is an essential part of the purpose. And I think our purpose is to come up, and the director's challenge is to come up with a complicated proposal, to come up with something that informs people whose signatures being sought what this is really about, and not just the good things that it does, like taking away your taxes, but without telling them the bad things it does, taking away the public services, including schools, parks, libraries, everything else.
Madam Chair,
Yes.
I do think it states in what Mr. Lidl has provide schools, community colleges, and other local units of government no replacement for real property tax revenue eliminated. I think that's a pretty clear indication that the revenue is going away. And again, whether I agree with the purpose of this or not, it seems to meet the requirement that some of the potential negative, if you are of the mind that removing revenue from some of these entities is a bad thing, it lays that out. And trying to put numbers on it, I think would be futile and nearly impossible given the fluctuations in these things.
Madam Chair, obviously Director Brader, the 100-word summary is under the direction of the Director of Elections, correct?
I have to prepare it and the board has to approve it.
Right.
So it's a shared.
So it is shared.
mission.
So what
Yeah.
I would like to see, because obviously we know we've been here, we will be here for a couple more hours. We know this, is that I would like to see, given Director Brader, given what you've been hearing on both sides, and remember, Dawn, I do agree with you on Lidl's thing, but because I feel it's important to discuss that exemption. I'm religious and educational. Because I also feel that it's important to say that the line of there is no replacement. So I think that as much as I know that we want to lay out exactly what it is, that's exactly what it does. So just reading through the language, and I am not a tax person, so if you've seen my body language, I'm trying to absorb all of this. But I would like to see what Director Brader comes in while we take a recess for lunch.
Can I ask a question, Mr. McCourt, before it's actually a two-parter? And this goes back to, this is the third time that we've had the ability here to kind of go through this. And I still have this going back to the first time. My first question, here's the basis for my first question, okay? In Article 9, Section 4, it says, it talks about religious and educational nonprofit organizations. And it simply eliminates all of the dialogue and says it's repealed. Now your point is that, well, that's a logical connection because we've gotten rid of all the property taxes, and you said real taxes. And I get the fact that you're making a logical leap there, but what's happening here is you're really not. What you're putting in the Constitution is religious and educational, period. Those are any exemptions are repealed. You're saying something different here than what you're explaining to me now. That's not the point I'm trying to make. The point I'm trying to make is the question I'm asking is who put this, when this petition was put together and all of this rewording was done on the Constitution and these modifications were made, was this done by a professional group? Was this did the grassroots organization that requested this go to a lawyer? Did they go to an accountant? Did they go to a group of informed constitutional folks that simply sat down and said, let's look at the logic of this? How did this come? Who put this together?
Who actually drafted the language?
That's
So
the name of an organization.
So the sponsor.
Sponsors
The
Acts
sponsors
Acts.
acts went to acts.
But I'm asking you.
Who actually drafted the language? I drafted the language. I drafted language in consultation with another constitutional lawyer, not my firm.
All of these changes constitutionally were made by legal people.
Yes.
Lunch has been brought in for us, and I think that that Member Bradshaw's suggestion is a good one. We can, yeah, Mr. Brader?
Yeah, I'll try to be quick, just sort of for some quick guideposts. So just, level setting. Axe My Tax is not required to do this process at all. They can use their own summary if they want to. Using the summary that I draft and you approve means that you can't later reject it on the basis that it's misleading. Basically. Court might still be able to, but you can't. Regardless of what happens here, if the signatures are collected, there'll be another discussion about what actually goes on the ballot, which isn't necessarily going to be the same thing as this. So that's what we're trying to accomplish here. We have always been able to come up with a summary that at least 3 people on the board voted for. I'm going to take a crack at incorporating some of these concerns. I will say on the question of purpose, I think you can reasonably interpret purpose to mean what changes to the laws it's making, like what are the purposes of this provision to what our Constitution says or what the statutes say. And you can also, I think, reasonably understand that to be what is the goal, and I think there you can get into the effects. In my experience in general, proponents of these initiatives generally are less interested in the summaries talking about the effects, direct or indirect, and opponents are more interested in talking about the effects. So that's just been and in general, I think we have sometimes sort of gotten towards talking about the effects, but the farther we get away from talking about the effect on provisions of law, and the more we get into what could be considered secondary effects, the harder it is to do that in a way that there can be consensus that it's fair and impartial and doesn't create prejudice for and against. That's not saying that we can't do it or we shouldn't try to do it, but that's the challenge. And that's why we've generally I've generally started with, and we've generally ended up settling on things that are more tied to the language in the provision. So I'm going to take a crack at doing this. A couple of things I just want to flag that I'm thinking about though is this question of whether alternative taxes or any sort of taxes on personal property can still be in effect. I think it's still an open one based on discussion. And I think the answer to that question is highly relevant to the question of whether the elimination of the tax exemption for religious institutions needs to be included. Because I think if it is still possible to tax any kind of property, then I do think the fact that we're getting rid of the religious exemption is important. If nobody can be taxed on any kind of property, then I don't think it really matters. So that's kind of an open question. I think in terms of, the other big question basically is, are we going to talk specifically about schools or other subdivisions that are not going to get revenue? Are we going to specifically mention them? And then also, to what extent are we going to talk about the way in which their revenue will be taken away, and questions about how it'll be replaced? I think I have enough to try, based on the discussion, to try to come up with something fair and impartial on that. But that's kind of the challenge, I think, based on the discussion there. So I think those are the two. And the last thing I'll say is, to accomplish some of this, we'll probably have to take out some of the numbers, percentages, details about what types of taxes we're talking about.
All right, I'm sorry.
And may I make my statement, as I always make, is that any petition, whether we have the 100-word, when we have the 100-word summary, any petition that goes in front of anyone, that is a legal document, and you should read it before you put your signature on it.
So we will recess until 1:30.
Let me try.
Okay.
Yeah, so we're back on the record. Chair Gerwitz's mic was out, but I think some people heard that. So I drafted a new summary, proposed summary. I know that there's already been some suggestions to change the proposed summary that Chair Gerwitz mentioned to me, but I'll read what I am proposing and then explain a couple of things as a basis for why the changes. So the new proposed summary would be: constitutional amendment to prohibit real or personal property taxes, require 60% of voters to approve local taxes, require a 2/3 vote of legislature for any substantial tax increase, increase percentage of state sales tax revenue being distributed to local governments instead of the state, shift 10% of income, marijuana, alcohol, and tobacco tax revenue from state to local governments, require tax revenue distributed to local governments be used only for public safety, law enforcement, courts, emergency response, and essential infrastructure, require implementing legislation. If adopted, schools and other local government units primarily funded through property taxes could no longer be funded through property taxes. So a couple of things I just want to highlight here. Throughout, there were a few small wording changes that weren't meant to be substantive, but just to save words. But the ones that were intended to be substantive to some extent, or at least people I think will have opinions about, are, so that the starting phrase was prohibit real or personal property taxes. That's condensing what was previously there. Obviously, we had a lot of discussion about whether the legislature could impose or enact personal property taxes if this were in our Constitution. I listened to that discussion, and I again acknowledge that I'm not a tax or constitutional lawyer, and I certainly wouldn't be the one deciding on behalf of the state of Michigan if a personal property tax could be enforced if enacted under this. But I was not seeing, based on the language, proposed amended language of the Constitution, what sort of personal property tax could be enforced. So that was based on that. And then flowing from that, because of that interpretation, I didn't think it was necessary to include the elimination of the exemptions from now non-existent real or personal property taxes. There's probably other ways of handling that. Perhaps just say property taxes instead of real or personal, but we can talk about that. I did say 2/3 vote of legislature for any substantial tax increase. That was partially to go away from the 0.1%, which I know there was disagreement about what that 0.1% applies to. Nonetheless, the statute doesn't require it to be legally precise. Chair Gerwitz had suggested non-minimal tax increase, which could have a hyphen and not add any words, which might be a good alternative there. I did take out some of the language specifying how income tax or sales tax revenue rather would go to local governments instead of the state. I took out some of the specifics there to save words. And I did just make a couple of other word saving changes there. And then the most substantial change probably would be the final sentence, which is describing the effect on schools and other entities that are currently funded mostly through property taxes, and that could not be the case. There would be, potentially other ways that could be funded, fees, or perhaps other portions of state tax that aren't part of that 10% that's allocated only for essential services. But without trying to imagine all the ways it could be funded, I just said could no longer be funded through property taxes. So that's the starting point. I know, again, as I mentioned, I'm sure many people have opinions about this, but I know Chair Gerwitz had some ideas. So there's my new proposal for discussion.
So I've suggested.
You need to make, oh.
I suggested, okay, cross out or personal, because it doesn't prohibit personal property taxes. Require 60% of voters to approve any local taxes. Require 2/3 vote of legislature for any non-minimal tax increase. Increase percentage of state sales income and other tax revenue being distributed to counties, cities, townships, and villages, and county, city, township, and village governments from the state. So then you can eliminate the marijuana, alcohol, et cetera. Require tax revenue distributed to these governments be used only for public safety, law enforcement, courts, emergency response, and essential infrastructure. Require implementing legislation, if adopted, schools, community colleges, parks, libraries, public safety authorities, and other local units primarily funded through property taxes could no longer receive this revenue. That's a quick one, but I think it's a significant improvement and makes it more specific, because it isn't local governments that receive the increased essentially revenue sharing. It's a limited number of entities. And I think that we need to make it clear that there are many governmental entities that don't get anything. But this is something I did only in 2 minutes. And so I would invite both Mr. Lidl and Mr. Brewer first to respond to this. Mr. Brewer, why don't you both come up?
Thank you, Madam Chair. I definitely agree with some of the language suggestions and the reasons that you suggest for changes. Let me just go through the language that the director has proposed. I agree with you that or personal should be stricken. Because to include that suggests that there's some language in here somehow prohibiting personal property taxes generally. There isn't. There is a prohibition of alternate forms of personal, but not a prohibition on personal property taxes generally. I also remind everyone that earlier versions of this proposal did include language that would do it. And so there's a solution for that. If the proponents of this proposal actually want their language to be clear and specifically prohibit taxes on personal property taxes, they can come back with a proposal that actually amends the Constitution to do it. But this one does not. And so this is not a true and impartial summary of the content of the proposed amendment as the statute requires. If you include that language, it creates prejudice for the proposal because it suggests the proposal includes a prohibition that is not included. And it's not worded in a way that apprises the signers of the subject matter of the proposed amendment because there is no prohibition. It's not a matter of, well, I don't see something that would allow personal property taxes to continue to be assessed. The legislature has the authority, and in fact, current law requires personal property taxes be assessed, regardless of whether the Constitution says they can or cannot. The issue here is the lack of a prohibition. So a lot of stuff on that one word or personal, I would urge the board to reject it, for that reason alone. I think you suggested adjustments to the next phrase, require 60% of voters to approve local taxes. And I think that a couple issues with that. The language is in the proposed amendment is actually a little different. It's technically not all taxes at the local level. It's those that are, it requires 60% of voter approval to approve any proposed amendment or amendments to approve a township, city, or countywide tax. So if you have something other than an amendment or amendments, or something other than a tax that's levied on a township, city, or countywide basis, and there are those taxes, that language does not apply. So again, not really accurate or factual summary of what the actual proposal provides. So there's an issue with that in terms of compliance with the duty before the director and you as a board today, in terms of what the legislature mandates the summary must do. And the next phrase, I do like sort of the change from substantial to non-minimal increase, because the language would apply to things other than substantial increases. Like significant would be not a de minimis tax increase, but it wouldn't necessarily be a substantial tax increase. A significant tax increase, technically it's not a tax increase, it's subject. It doesn't even have to be a tax increase. The language used in the proposal is any law change in a tax law that would result in state revenue increasing by more than 0.1% over 5 years. I mean, effectively, because you have to look into the future, I can't envision a proposal where folks wouldn't make a determination where 2/3 vote requirement. But technically, and this isn't fall in the category of, legal precision, right? Because that applies generally to the subject matter of the proposed amendment. Here, we're talking about true and impartial and not creating prejudice. And if you're describing something in the tax here, approval of a tax increase, and that's not technically what the language provides, not accurate. I think next in the next phrase, as the chair suggests, the language suggests that it's distributed to local governments instead of the state with no qualification, right? To any average reader based on standard plain language reading, local governments, it suggests it's all of them, right? And clearly it's not. This proposal only provides for the transfer of a portion of state revenue to counties, cities, villages, and townships, and the language should be clear, right? The next phrase is the technical issue. I would note that all of the revenue from, income, marijuana, alcohol, tobacco tax revenue, some portions of that revenue technically don't go to the state. There are portions of that that do things like fund convention centers and some other things. So that's not as completely clear in terms of what actually occurs under current law. Again, we see this language in the next phrase, require tax revenue distributed to local governments. Again, suggesting that all local governments would get some distributions of revenue when, as we've discussed, many would not. And then I guess the last sentence, particularly with the chair's suggestion, isn't really necessary, right? So in my opinion, if you say that you're prohibiting property taxes, you don't have to say a second time that units primarily funded through property taxes could no longer be funded through property taxes. You've already said that. You've already said that property taxes are prohibited. So I think that would buy you some space. And then lastly, I would return to the language that we talked about earlier that was in my suggested language. Clearly, this does not prohibit personal property taxes. Personal property taxes would be continued to be assessed under the current General Property Tax Act. The proponents had previously proposed repealing the General Property Tax Act. They haven't in this proposal. Personal property taxes would continue to be levied if this proposal were adopted, which means the exemption from personal property taxes for nonprofit, religious, and educational exemptions is something that this proposal does, and the voters should be notified. Similarly, the requirements that currently apply to personal property taxes, that they be levied uniformly at 50% of true cash value and equalized. I believe the voters should be advised that the very significant impact, content, portion, purpose of this proposal. So those are my suggestions. I think you could get there, with some modifications of the language that I had originally proposed, as Member Daunt had suggested earlier. Moving forward from here, I think I see some potential paths. If you do something that addresses the issues that I've raised, go with some language that looks similar to what we shared and Member Dawn has suggested. I suspect we could, like we did with Proposal 3 on reproductive freedom, reach agreement with both sides on what the 100-word statement should be. If not, I think there's a few other potential paths for everyone involved. If the proponents want to be clear that they are also, repealing personal property taxes, come back with a proposal that does it. And my objections over the failure to include the impact on religious exemptions and uniformity, et cetera, go away. No need to include that in the summary. If this proposal actually repealed personal property taxes, I'd agree it wouldn't be necessary. And so they could come back with a proposal that could be better summarized at a future date. I think the proponents also don't have to opt to proceed with this process. Both the approval as to form and this summary process is optional. Nothing prevents them from taking their proposal with whatever summary and circulating it. But those are the potential paths I see at this point. Happy to sit with either proponents council and Mr. Brewer, or proponents council, Mr. Brewer and Director Brader. However, the director and the board would like to proceed to see if we could negotiate a 100-word summary. But otherwise, if you were to proceed with something that looks like what Mr. Brader has suggested, in my view, there are multiple ways it does not comply with the requirements of the election law. And even if you were to approve something that looked like it, the proponents would risk, litigation appealing the determination by the board, and they could be out circulating signatures, and they would be invalid because you have a court determined that the summary didn't comply with the requirements that the legislature has imposed. So.
Brewer?
Thank you, Madam Chair. Thank you, Madam Chair. I agree with Mr. Lidl with two important exceptions. First of all, I think that last sentence about the defunding of school and local governments is critically important. I think it should be moved, frankly, to the beginning of the summary after it says prohibit real or personal property taxes. And again, I agree with Mr. Lidl. This does not prohibit personal property taxes, so that there's a direct link and people understand the consequence. We're going to prohibit real property taxes, which will lead to the defunding of public schools and local government units. I think you could shorten up that last sentence, save some words, but don't bury it at the end of the summary, which
Can I-
nobody reads, frankly.
Let me make a suggestion. I think this is good. Increased percentage of state sales income and other tax revenue being distributed from the state to county, city, township, and village governments, but not to school districts, community colleges, libraries, or other governmental units.
That helps, but it's still not as direct
Okay.
as your
saying- yeah.
existing last sentence.
Right, but I agree with you that it, moving it up front, because I think defunding all of these entities for people to understand that is critical.
And the other thing I would add, Mr. Lidl talked about the possibility of litigation if this summary or anything similar to it is adopted. My client and I will litigate this improper summary. It doesn't comply with the law. We will litigate if necessary, because it's absolutely vital that if we're going to make this kind of significant change, as Mr. McCord said, to the tax laws of the state, that people signing the petition know what it means. This does not tell them what it means, and they will take an enormous risk of circulating petitions while we litigate, and in hopes of getting this struck down, and the petitions will be for naught. We will litigate.
Mr. McCord, do you want to respond? Perhaps.
Good afternoon. Reading the summary that the
Sorry,
director,
what?
reading the summary that the director prepared over the lunch hour. I think it's fair. I mean, I understand the concern with the schools, and we can live with that language. I can also say that, we would welcome the opportunity to discuss this matter with Mr. Lytle if he is so inclined and so open-minded about it. On the other hand, we can argue over this all day. We obviously have a disagreement regarding the effect of personal property taxes, whether personal property taxes are eliminated by this proposal or not. That's really kind of for a court, I guess, to decide. But even if a court did decide that personal property taxes would remain in effect, then still under current law, school districts and religious institutions would still remain exempt from the levy of personal property taxes. The statute already provides the exemption for it. So, even though the constitutional provision that was put in, while it's there, it's also a function of statutory law that there is an exemption already in place. So the removal of the exemption in the Constitution would not collapse or eliminate the legislature's exercise of providing an exemption from personal property taxes for those types of entities. So I think to a certain degree, we might be able to come to some agreement on this whole personal property tax issue, but whether or not it actually produces the effect that one side proposes, I think it's not consistent with existing law.
With regard to the other suggestions, and I know that they need to be put together again for us to look at. Did you have any other comments?
Well, I listened to the comments and they're fine. I mean, I would have to actually see them in writing, to be perfectly honest with you. And I see Mr. I've scratched down as many as I could. But to a certain degree, I'd have to like read them through again. I haven't counted them up to see if they meet the 100-word requirement. I mean, there are a lot of words. I mean, so I don't know. I mean, I'm open to having a conversation, but not if the conversation is just to sit around and have a conversation and not really get anywhere.
Madam Chair, I mean,
Yes.
and I'm sure that's one thing that we have, I don't recall us ever having a 100-word petition that did not, we wouldn't be able to,
We've always gotten one.
we've always gotten
Yes.
one here. My question for you is, how do you feel about the wording about the uniform assessment that was brought up by Mr. Lidl? That it's removal of this would allow for something that's not uniform.
Now,
It's his wording. I'm just
it would only be, assuming all that to be correct, assuming that it would only affect personal property taxes, assuming that personal property taxes are not eliminated by this proposal. So again, those, you gotta get to two, I'm just saying, those are two legal assumptions that we have to make, right? So the assumption one is that it's not eliminated, right? We say it is, you say, your assumption is not.
You're asking citizens, you're asking registered voters of this state to sign a petition, but you're sitting in front of me saying that's a legal question, but you're asking people to sign a petition to change the Constitution.
Let me put it this way. We're asking them to sign it because we think it does do exactly what it says, that is, it does eliminate personal property taxes. So if it eliminates personal property taxes and real property taxes, then the function of uniformity becomes also a moot point. So you can remove that from the Constitution.
I'm sorry, I'm just struggling on the fact that I'm still trying to understand. I want to get to a ground that we can do this. So, but I'm going to defer to my other board members. I know, Tony, I saw you light yours.
You essentially asked the question I was going to ask, which was it like the agreement or lack thereof on whether or not the belief, intention, etc., is that this eliminates personal property tax. And I'm excuse me, I'm with you on the new confusion on my part of does it or does it not? And I think that's a key issue here is if you're, and I'm not trying to be snarky, but if you are telling us that, well, that's a legal question and we'll ultimately leave it up to you guys on the summary, then that gives me pause on creating a summary on, because that is a significant issue. Does it or does it not eliminate personal property taxes? It sounds like you intend it to, and you think it does. Mr. Lidl and Mr. Brewer are confident that it does not. And yes, we should get we want to come to 100 words, but if you're giving up on the fact that, oh, well, it actually doesn't eliminate personal property taxes, then that's a concern.
No, it's not a give up. The question asked said, as I recall the question, as I recall the question, the madam put the question was, explain the effect of the elimination of uniformity. Right? So, and so that question, the effect of what would this proposal do as to the effect of the elimination of uniformity? That question has to assume then that personal property taxes are still in play. That's what I said. That's how I said it starts with an assumption that personal property taxes are in play. We believe our proposal eliminates personal property taxes, but
Mr. McCord, just listening here, okay? We're going through all of this motion on the 100-word summary. And from just sitting back and listening to you, it's almost like you're trying to figure out what this proposal is all about while we're writing the 100-word summary. It shouldn't work that
no,
way.
yeah, I appreciate that.
I'm sorry?
I appreciate that. Yeah, I agree. I'm all I'm saying is I think the summary as originally proposed on the, what was it, the 17th of this month, that was in the agenda, fairly represented our proposal. Right? I believe our proposal eliminates personal property taxes.
But again, it's almost like we're trying to divine a proposal here that you've already got the proposal.
Right.
But this proposal just seems to get, just to be blunt, this proposal looks like it started as a great idea that just never got baked. It looks like an idea that got talked about, put together, but then when it was executed and brought to us, it's like, well, yeah, we didn't think about that. Or yeah, well, maybe this doesn't really say this. Well, yeah, okay, we scratched this out, but what does that translate to? Well, we don't know. And I'm not being kind, and I apologize. I have a huge amount of respect for what you're doing. But it seems like it seems like we're trying to listen to a defense of something that hasn't been thought all the way through. Tell me why I'm wrong.
Well, I would say it has been thought all the way through in the sense of the sponsor proposed to eliminate real property and personal property ad valorem taxation in the state of Michigan, which is provided for in Section 3. And we thought our proposal did that. I still think it does that, right? I mean, the objectors clearly have raised arguments that it doesn't do what it exactly says. But I think it does what it says.
You believe it eliminates personal property tax?
I do.
Mr. Grill,
Do you own any personal property?
it's, is,
I got brought with me today.
it, going back to some time ago, my initial question about that Section 3 and the striking out. Are you familiar with court cases where we could have that would provide us some clarity on whether or not the way they have done this is in fact a repeal of the personal property tax issue? That is the genesis of the main concern here.
In fairness, I have not had the opportunity to conduct the level of legal research I think that would be necessary to give you a definitive answer on that. Tax law in this particular section of the Constitution is not something I have personal expertise in. It would require specific research for me to give a conclusive response to that question. I would need time.
Thank you for the honesty.
Or did you have something, Chair? Well, so I mean, there was mutual interest in trying to come up with a compromise summary. I'm happy to participate in that discussion. If we can do it briefly, I know we have limited time and one more to get to. I think it might be possible to have a 100-word summary that is both fair and impartial and accurate, even if it doesn't lead one to believe that there's any clear answer to that personal property question. So it's possible we could negotiate that language. We can obviously, the board obviously should feel free to discuss further as much as you want, but I'm certainly happy to see if we can take a few minutes to hash something out with the lawyers.
I think that is a good idea.
Are you suggesting a
Yes,
recess?
yeah.
Okay. We will recess for until 2:30? Is that enough time?
35 maybe.
Okay, 2:35.
Okay, okay.
5 o'clock.
How about to prohibit real and or person, no.
Yes, in the interest of time, I'll just say that the proponents and opponents council discussed this with myself and Adam, and we're all comfortable with this language if the board is. So I'll just quickly read this. It is constitutional amendment to prohibit real property taxes, which currently are the primary funding source for schools, community colleges, parks, and other local government units. Shift 10% of state sales, income, and other tax revenue from the state to counties, cities, townships, and villages, but not to schools, community colleges, parks, or other local government units. Eliminate property tax exemption for religious and educational organizations. Require 60% of voters to approve any local taxes. Require 2/3 vote of legislature for any non-minimal tax increase. Require implementing legislation. And that's only 83 words. Yes, so the question was, is this
So-
acceptable to proponents and opponents? And
Parties have agreed upon this language? Okay.
Like Pat wants to.
Paul? It's Paul, right?
I'm sorry,
Oh, did you have something,
Mr.
Paul?
McCord?
Mr. McCord. You look like you wanted to say something. You're like, I don't want to say anything.
I'm sure are all very lovely people and we would have a great time at a cocktail party, but I don't want to have any more conversation about this. So that being said, the three of us, Mr. Lytle and Mr. Brewer and the director and Mr. Fakasi, we sat down and we worked out. It's a compromise. Is it perfect? No, not perfect. But does my client fully agree and accept it? No, but it's a compromise that we came to keep moving the process going. I suppose the opponents, probably would say, yeah, there's some stuff we would like in, maybe change some language, but again, it's a compromise that at least the proponents and the opponents can live with.
Thank you. And I will speak for us by saying that we really appreciate the efforts to work together and to compromise, which is something that should happen more often in government. So if it's agreed by everyone, do we have a motion or do we want to discuss this further? I hope not.
Hell no.
Okay.
You want to make the motion?
I move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by My Tax as drafted by the Director of Elections and presented by the Director on January 19, 2024.
I'll support.
All in favor? Aye. Motion carries. No, congratulate everyone. And now we move on to item 7, which is consideration of the form of the constitutional amendment submitted by My Tax. So we have Mr. Brewer, Ms. Flower, and I think that's it on item 7. Mr. Brewer, you want to?
Before we start, I just want to note time check. So we do have another petition to get to that we need some time to discuss. I'm sure we're supposed to be out of here by 4:30. So we have to try to move as quickly as possible.
Mr. Brewer.
Thank you, Madam Chair. I have nothing to add to my previous testimony. You cannot approve this petition as to form because there is an insufficient list of the alternate abrogated provisions of the Constitution. The rest I will leave to Ms. Flowers.
Ms. Flowers, welcome back.
Is this on? Okay, perfect. I had good morning on my notes, but it is now thoroughly the afternoon. So good afternoon. I'm here with my partner, Steve Liedl, representing Citizens to Save Our Public Safety in Schools. First and foremost, as the letter we sent last night indicates, we really don't think that the form of petition should even be considered at today's meeting. It was received well after the 48 hours that it was supposed to be submitted to this board, and it's left insufficient time for this board, for opponents, and for the public in general to actually review what the crux of the amended petition is, and if there are just the changes that have been indicated in the cover letter or other changes that may have been inadvertently included. So our first argument is that it should not be considered. If the board does consider the petition or considers the January 4th submission or 5th submission that was noticed by the board on the website, we wanted to include the following considerations as to the petition form. So Section 482 requires that the full text of the proposal be included after the 100-word summary. The petition manual on page 17, or the petition manual indicates that where the full text cannot be included on the first page of the petition, there can be an instruction to refer to the reverse side of the petition and the accordion fold pages. In the first page of the petition, where that instruction lies, there's no reference to the new provision that would be added by the proposal, Section 43, which is the section that would effectively implement require the legislature to implement legislation effectuating the proposal, which Mr. McCord has relied on heavily in his arguments today in explaining the proposal to the board. Second, we also would emphasize that the certificate of circulator doesn't match the required statutory language like stand-up democracy requires strict compliance to Section 482. And then our third issue with the format is that in the printer's affidavit that was provided timely to this board, there's no indication of what font was used in the petition, which makes ensuring the correct type size difficult, if not impossible. So that printer's affidavit is provided in form by the board for petitioner proponents to use in their submissions. And it was submitted incomplete and not in compliance with the procedures that this board has set out for itself. Then generally on the second or after the 100, my final comment is that after the 100-word summary on the pages of the accordion folds, we would note that the full text of the proposal indicates that there are certain sections that are amended. And then when you look to the actual text of the proposal, those proposals are actually repealed. So there seems to be some inconsistency as to the instructions provided in the second pages of the petition as compared to the first pages. Any questions? Mhm.
Nope. Mr. Brader, if you could comment on the issue of timing that was raised by Ms. Flower, I think that would be helpful, of when it was turned in, et cetera.
We got Adam. I think I'm just going to defer to Adam rather than get something wrong.
So the first petition came in on January 4th. It was submitted with the Bureau of Elections on January 4th, and that was the version of the petition that we published and emailed to our subscriber list on January 5th. The full petition was put on our website, and it remains on our website since then with the announcement link that we put out soliciting public comment for the director to draft language. On Tuesday, we put out the agenda closer to the end of business day, roughly. Again, posted it on our website, emailed it to our subscriber list, indicating that this was the summary language and providing the full agenda for the board meeting. So that was on Tuesday, January 16th. We then received a copy of the petition on January 18th, which was yesterday at 4:30, which just added the language that was drafted, that was on the agenda, added it, I'm sorry, the summary that was posted on the agenda, added that to the top of the petition. And then this morning, about 9:30-ish, we received an updated copy of the printer's affidavit, which which you guys also have in your packets today. That's the.
Thank you.
So the original one that we got on the, I'm not gonna go back to the right. So the one before the one we received today, the affidavit did not have the type of font.
That is correct.
And main difference, only difference in the January 4th version and January 18th version is that the summary language as drafted that we started with today was inserted. Everything else remains the same.
I believe that that is what is being represented. I will say that because it was submitted at 4:30, I don't believe staff had looked through the entire thing.
And that's the crux of our argument, is that if the board hasn't had time to sufficiently review, there can be errors, there can be inadvertent things that happen between mock-up, between what you submit to the printer, what they mock up, and what they decide to print. If the board and opponents have not had sufficient time, we would argue that it's not appropriate for consideration and approval today. And that would be consistent with your own rules and procedures. On page 17 of your manual, there's very clear instructions about what needs to be submitted, when, to what email addresses, and there's not really a compelling reason to depart from that here today.
So we've done a heavy lift today on the summary. If my knowledge of serving on this board serves me correctly, Member Bradshaw is not going to allow for conditional approval.
That is correct, Member Daunt. I will not approve in a conditional approval because the petition as to form does not have the summary that was approved today. It's kind of the old adage, I want to see it, I want to have it in front of me before I approve it. I will not be a yes vote on approval to form today.
And though I disagree with yours, I respect and you're consistent. For me, in reading through, we've got these issues raised by opponents. In reading through the language, I did notice several significant typos, misspellings of words, things like that, where it may seem like kind of a non-important issue. And I know we've had even litigation about spacing and things like that, but I think we should strive for as much accuracy as possible. So I think what I would suggest is I don't know as we need to deny as can we pull this or what, and put the new summary on, fix those typos, and then resubmit one last time where we've fixed all of these issues, and it should be
not be resubmitting the summary in any way, shape, or form. It would be more of a formality to come back with it's in your best interest. But if you were to willingly pull it back at this point in time, then we don't have to vote on it. Is that correct?
That's what I'm suggesting and thinking.
Mr. Brader, would that be the?
Yeah, I mean, it's really up to the sponsor. I mean, again, this is a courtesy. It's not a statutory requirement that they get approval as to form from the board. They do need to submit a copy to us before they start circulating of the version that they're circulating, us being the Bureau of Elections. So the sponsor could come back, get approval as to form, and then start circulating, with the assurance that the board had approved it, or they could start circulating and
still
take their chances.
Or take their chances.
And come back in. Yeah.
I mean, all things considered with, given member Bradshaw's position and then these issues I've noticed, those are fixed. I'm comfortable with approving to form once those issues are corrected.
I do notice, I'm looking here at the at the position letter, which indicates that the certificate of circulator is not properly drafted in the petition. And while I've had some disagreement with Stand Up for Democracy, that's the law. It's got to be very specifically in compliance. So I think, Member Dawn, that deferring approval as to form until the form is in fact compliant is a good idea. We have not yet addressed other issues that are raised, but we don't need to. Thank you very much. So we're not gonna,
Well,
we have to have a motion on.
It's a motion, but I think that we need, sorry, I don't have any. Would Director Brader or to Adam, do we need to procedurally, does the sponsor need to let us know what their intention is?
I would say I mean, I think it'd be better for the sponsor to indicate what their preference is. If they want you to take a vote on this, sounds like it won't pass, but that's up to them, or they could withdraw it and we could just move on.
In the meantime, I ask a question. I know it is on our agenda. Our next meeting would be that February, would it be the February? Sorry, it's all electronic now, so. Yeah.
That is the next currently scheduled regular meeting, yes.
We can't guarantee that's the exact date we'll meet. Like, for example, if there's a recall petition, sorry, Mr. McCord, you could have a seat. You know, if we have something that requires us to meet earlier than that, we may have to reschedule, or we may move it back a few days if there's something like a recall petition that necessitates that.
Got it.
McCord?
Yeah, can we get on the record exactly what typos Mr. Donda is referring to?
I don't think so.
So on the first page, for instance, on the first page, section 36, tax on tobacco products, dedication of proceeds, down in the all caps portion, 10 percent is in there a couple of times rather than percent.
Could I suggest that if you want to solicit Mr. Dawn's help on this, that you do it after, because we have another 100-word summary to consider and we have 1 hour and a quarter.
And there was those, and there was an additional one I noticed nearby that I can't find right now, but I believe it was the word article was misspelled. And generally, as somebody who proofreads a lot of things, if there's mistakes like that, there's likely more throughout the document. And I think it's in your best interest to fix those.
So, Mr. McCord, are you withdrawing and you'll be back for, thank you.
I just want to know, just for the record, because it was brought up, is that the thing about box versus line in the circulator statement, that's actually in 544D, and that is a substantial compliance provision rather than a strict compliance provision. So we put box in there on our instructions intentionally, because that's what's generally actually on the form, not a line.
Thank you.
Is that right?
Okay, the next item on the agenda is consideration of the 100-word summary of the purpose of the initiative petition submitted by Citizens for Local Choice. The summary is drafted by the Director of Elections is as follows. Initiation of legislation to amend the Clean and Renewable Energy and Energy Waste Reduction Act by eliminating the requirement that applicants undergo state certification before construction of certain wind and solar energy facilities and energy storage facilities. Under current law, in addition to local approval, applicants for construction of these facilities must obtain state certification, which requires meeting state requirements, including an application fee, public comment, assessment of environmental, natural resources, and farmland impact, wages and benefits requirements for workers, setback distance, size and height of structures, and amount of light and sound emitted.
Madam Chair, before we begin any kind of bringing anyone up, I do believe that it is important for me to disclose that I am employed by the International Brotherhood of Electrical Workers, Local 58 in Detroit. I am a licensed electrician. And I do feel it's important for me to let anyone who is before us know that that is what I do for a living, but I wanted to at least put that on the record. I know we had another petition that came up before us, but I do feel it's important for you to know. I have been on this board since 2013. I feel that I can be impartial of what is in front of us, and actually do my job unless there's discussion among that. So I think I did that correctly last time I did that.
And I believe you consulted with Mr. Grill, who advised that there's no conflict issue. Is that not true?
Not entirely sure we should get into what was discussed or what the advice was.
Okay. So Mark Brewer has indicated that he wishes to speak to this and has provided us with a position letter. Mr. Brewer? It's a busy day for you.
Yes, Madam Chair, it is. I'm blessed with a very interesting practice. Mark Brewer of Goodman Acker, on behalf of Our Land, Our Rights, which is a ballot question committee opposed to the Citizens for Local Choice proposal. Chair Gerwitz indicated that you all have copies of my submission, because I'm going to reference that, particularly the alternative summary that we got there. So I want to make sure that you all have that. I have extra copies in case you do not. I'm not going to spend much time on the CLC's proposed summary. I went into great detail in my written submission about why it is deficient, inaccurate, and biased and so forth. But I would like to spend a few minutes on the director's proposed summary, which with all due respect to Mr. Brader is also deficient. Frankly, the summary is simply not true. In it, there are a couple of statements that applicants in this process must, quote, undergo state certification or, quote, must obtain state certification before constructing certain energy facilities, which are subject to Part 8, which is the repeal at issue here. Obtaining PSC permission to build is optional, voluntary, and available only in narrow circumstances. So it's incorrect to say that that is required or must be obtained. And because the summary drafted by the director begins with that erroneous premise, the balance of the summary really is insufficient as well. And beyond that, it of course fails to describe the numerous effects of repeal, which are detailed in my letter. To assist the board to move the process along, I submitted an alternative summary, which we believe complies with the law. And I'd like to go through that summary clause by clause with you. The very first clause indicates that the proposal, if adopted, would amend the Clean and Renewable Energy and Energy Waste Reduction Act by repealing the law authorizing state regulation of certain wind and solar energy and energy storage facilities before construction. That is taken directly from the title of the part of the law that's at issue here. So there can be no question about its accuracy. It comes directly from the title, and that's what that provision does. The next clause, if adopted, this would give local governments complete control over energy facility construction. Again, a true statement of the effect of the adoption of this proposal. The third clause that is that the adoption of the proposal would have the effect of raising utility rates for individuals and businesses and reduce energy reliability. Utility companies of this state testified before the legislature that the law sought to be repealed will assist them to keep rates down and improve energy reliability. In DTE's most recent integrated resource plan approved by the PSC, DTE indicated that it was limiting the pace of renewable development in this state because of its recent bad experiences with local government control of construction of those facilities. It detailed and provided analyses showing that if the pace of renewable development was not limited by local government control and abuse, frankly, of that process, it would choose to build a lot more renewable facilities and would reduce future utility rate decreases in the state for DTE alone by 1.4 billion, projecting that statewide, you're talking about $3 billion. But because this provision would be repealed under this proposal, those are rate increases that the ratepayers of this state would see. The next clause that we would add, take away property rights created by the law for farmers and others who want energy facilities on their land. The law proposed to be repealed is replete with protections for the property rights of landowners, including farmers, on whose land energy facilities are constructed, as well as adjacent property owners. So property owners on whose property these facilities will be constructed are protected, including farmers, as well as adjacent property owners. If this law, if this proposed, if this petition goes forward and is adopted, those property rights would disappear. This would also have a significant negative effect on tax revenue and financial benefits for the communities of this state, which is the next clause in our proposed alternative summary. There can be no doubt that energy facilities produce property tax revenue and jobs, who then generate, and those jobs, people who hold them, generate additional economic activity, which sustain local businesses, who all of whom pay taxes. We've seen already thousands of jobs created in this state by the creation of these facilities. And also, in addition to that, under certain circumstances, the law sought to be repealed, mandates direct utility payments to local governments. If energy facilities are not built and or this law is repealed, those benefits will not be created. So this is a true and impartial description of what are the effects of repealing this law. This law also provides significant protections for workers who build certain energy facilities in this state. And repealing this law will eliminate the rights of those workers, and that's another clause that we've added. And finally, there's no doubt that solar and wind energy facilities reduce pollution, thereby improving public health in this state. Hindering their construction or stopping them altogether by repealing this law will limit pollution abatement and harm the public health. So in sum, we have submitted an alternative summary which we think accurately describes the proposal and describes the consequences of it. I'll just offer this in closing before I take questions. This is a complex law, Part 8. You cannot possibly describe in 100 words the procedural issues, but that's the rabbit hole down which the first two summaries went. It's impossible to talk through in 100 words or less, go through all the procedural issues here. So I think it's better to describe the law and its repeal and its effects, which is what our summary does, rather than bury potential signers of this petition in these arcane legal details, which really are meaningless. They should know, they should be informed of the consequences of repealing this law, and that's what our alternative summary does. With that, I'd be glad to take questions.
I have, before I ask you questions, I would like to direct this to Mr. Brader. We got the summary, we got the proposal. And I looked at it and I couldn't understand what it was about at all. I didn't have a clue. There was a proposed from the proponent, a proposed initiated law to allow local units of government, et cetera. But that has nothing to do with the language of where it says the people of an initiation of legislation. The language initiating the legislation, so far as I can tell, crosses out a phrase in the title of the act with which they are disagree. And then there's a phrase which is crossed out later, but I just don't know. We spent, I don't know how many hours looking at the Axe My Tax petition and trying to understand if the summary accurately set forth what the petition said. This petition doesn't say anything, so far as I can tell. So I'm just really puzzled. And I assume, Director Brager, that you read the statute, which I downloaded, enrolled House Bill 5120, and tried to figure out what it meant, but that doesn't make sense to me. I just don't know what we're doing here.
Yeah, so I mean, I think substantively the critical part is sort of at the end, where it says enacting Section 1, Part 8 of the Clean and Renewable Energy and Energy Waste Reduction Act, 2008 PA 295, MCL 460-1221 to 460-1232 is repealed. So as I read it, all those sections of law would be repealed. And that's what the proponents had suggested a summary for, based on what they think the purpose would be of removing those sections. And that's what I drafted my summary with an eye towards, with a focus on what I thought was the most important part, which is the state certification process. I agree with Mr. Brewer that it's completely impossible to summarize everything this does in 100 words. In terms of whether it's a required or optional process, I'm interested in hearing from the proponents on that as well, but I'm certainly open to rewording that if it's not really accurate in describing who has to do the certification and what it is. But I think regardless, we're going to have a challenge of a major challenge in determining the core elements of what this does, given the fact that it's repealing a complex multi-section part of the code.
It's a complicated law, and the initiation of legislation just says part of this law is repealed. Is that correct?
Yeah. It just repeals sections of law, yeah.
Without advising in any way what the law is that's repealed. So.
May I comment,
Yeah,
Madam
I
Chair?
appreciate it if
Yeah.
you would.
The more transparent way to do this would be, rather than the repeal, they could have simply come forward and say, we're amending this, and did as they did in the first two sections you indicated, Madam Chair, and go through all the language from the bill and strike it out. That way it would have been on the petition and people could have read for themselves, oh yes, this is the language they're getting rid of. So this is the least transparent way to do this proposal. I won't speculate on motives, but the far more transparent way would have been to treat this as a straightforward amendment, put the entire bill on the back of the petition like is usually required, and strike through everything that was being repealed. That would have been the more transparent way to do it. But it's not. And so that's what you have before you, that anybody, any voter or any signer looking at this would have no idea what it is they're signing off on. I don't think they could even go, and I know Mr. Dawn has suggested this in the past, I don't think they could even go find this bill very readily so they could figure it out. I mean, it's just very, very difficult.
I have kind of a hard time finding it.
Yeah, it would be far easier and
I
far more
can find my
transparent
way around MCL.
if this were reproduced on the petition, as is the common practice.
Yeah, is there somebody here representing Ms. Hanson? I'm sorry, because I should have seen that's who your client was.
No, that's okay.
I
Andrea
can't see you
Hansen,
again.
Honigman Law Firm, here on behalf of Citizens for Local Choice, here to discuss the summary of the purpose for our proposed initiative, and appreciate the opportunity to weigh in and for the director preparing the draft. First, why don't I just upfront deal with your question, Madam Chair? So the reason that it is done this way is because, one, that is the legislative process. That is how they do it. So when they do a repeal of an entire section, they say this section is being repealed. That's what they do. When they do an amendment where some of the section is remaining, then you do the strikeout. That's just the legislative process. It is also the process of every petition that I could find, and I had one of my colleagues looking too, who between the two of us, we've had, quite a bit of experience of how that's done. It was how it was done with the prevailing wage when it was a repeal. It was just repealed. They did not set forth the entire statute of what was being repealed. I mean, even in the raise the wage petition that Mr. Brewer did, the sections that he repealed, he just said they were repealed. He did not restate them all and strike them out. So that is standard process legislatively, which is generally what this board follows, because we are to follow the form of legislation. And it is also the practice for this board. I found, I believe, 3, entire repealers, and they were just said it was repealed. And I don't know why. The reason is that the legislature does it. I'm assuming when you do a repeal, it's pretty easy to, you find the law, it's being repealed, it's all gone. When you're doing an amendment and you're just changing some of it, it's important to show what the changes are and what's staying so that you can fully understand the scope of what is being done. So that is why it is that way. To require something different would be to be going completely, it's not the legislative process. It's not what the legislature does, and would be completely inconsistent with every petition that I have been able to find that's come before this board and been approved when there's been full sections that have been repealed.
Madam Chair, can I ask a question?
Yeah, please.
Because it's been a long time though. When you went through and you're trying to figure out like repeal and amend, it looks like you have an amendment and a repeal.
Well, so we are amending the
I was gonna
statute.
I was gonna go a little further.
Right. Oh, I'm sorry. Go ahead.
So it's okay. And it's Director Brader or to Adam. Have we had like amendment and repeal before?
The raise the wage petition.
Raise the wage, that's what I figured, because I'm just trying to look at, I looked through here because I'm always that proponent of, read what's on the back of, I say it all the time, every time. I know you've heard me say it, don't put your signature on something that you haven't read. And so I went through, although I will admit it was a little bit late last night and I didn't get the 2-part, but I was looking at the MCLs, trying to pull those up to see exactly what does all that entail. And then I only found like the 2 sections, but I didn't know exactly, I didn't go far enough on the MCLs to keep on going to see what else has been repealed. Because I only got as far as, I think, MCL 460-12221, and I believe like 122, I can't remember, it was early. So as someone who like just looks at it, it's a lot of information.
It is.
Yeah.
And
I can see where trying to get a summary would be a little I just want to make sure I was right on that we did do amend repeal again.
Yes. I mean, and that again is consistent with the legislative process. We're not repealing the entire statute, right? To do a straight repealer, which would still actually be from an initiative standpoint, an amendment, but it's, we're not repealing the entire statute. We're just amending and repealing certain sections of it.
Question for you. Is this, am I correct that this is limited only to solar and wind?
And solar and wind and energy storage facilities.
Energy storage. Okay. So it doesn't spill over into anything else.
No.
Somebody wants to go drill a well on their own and.
It's not part of this.
Okay.
Piece. So I thought, I've been here all day, as have all of you. So I really have actually been crossing out things. I'm going to try and be as succinct as possible, but make sure that I, get what I need to across. And some of what I wanted to say was just a minute about the process, because there's been a lot of discussion here about effects, and I feel like a lot of policy discussion too. And so I just wanted to remind the board and tell those who are more new that, prior to through the 2018 election, we did not have this process. So sponsors wrote their own summary. So a lot of the examples that you've heard or seen, they're really not relevant to this discussion because they were prior to the process that we have now. So the law was amended. So what would happen is a sponsor would have, and they would just write their own summary. Sometimes they were good, sometimes they were terrible, sometimes they made absolutely no sense. Some of them were, they were from the sponsor's perspective. So they were not always entirely accurate. And so I'm assuming that is why the law was changed in December of 2018 to require the director to prepare the summary and this board to approve it. And the point of this, I believe, was to address what some of the issues were, and that some of the summaries were very one-sided or just factually inaccurate. But those of us who may have opposed it, maybe it just wasn't something that was that appealing to the courts to deal with, I think, with a summary issue. So the legislature put something in place so that presumably the director, who I think, has, not the best job in the world to have to do this, to try and come up with, something unbiased and factual on a variety of legal issues and have this board approve it. It's not supposed to be, a big contested proceeding on policy or I would argue the effects of a proposal, because the sponsor is in the best position to say what the purpose of a proposal is. Now, I think sometimes the effects are obvious. If you have a constitutional amendment, well, any law that is directly contrary to that is not going to be in place anymore. I mean, there are some effects that everybody would agree to. Most of what Mr. Brewer said today, I would say, is policy and it's opinion. And for almost everything he said, could have people here who would say the opposite. It's not something that should be part of a summary. A summary is just supposed to be, it's true, accurate. It's not going to cover everything in a summary that the proposal does. It's 100 words. So I just wanted to say that and say, the first proposal that you guys ever approved was in 2020. So this is still a relatively new process that I think you all are still kind of figuring out. And so it's just kind of my observation that I feel like this is getting maybe a little bit more tedious and contested than I think anyone is really enjoying. So with that being said, I want to move to the actual summary because that's what we're here. And I'm really hoping that we can do this quickly and actually get this done today. And while the summary that was written and drafted by Director Rader is definitely different than the one that I proposed, I do recognize that that's not the standard, and the standard is not, it's not what I like or my client likes, right? That's not what we're here to do. That being said, I do think there are some things that are not accurate, and the summary is required to be accurate. So I really am trying to just focus on the parts that I think are inaccurate, either by what they say or what they don't say, and not try and redraft, because I do think some deference should be given to what the director has done. I think that's what the legislative intent was. So to be fair, and I think as had been acknowledged, this is pretty complicated. I've had to read this multiple times to understand it myself. And it's not an easy one to prepare a summary for. So I thought it might be helpful for me to discuss at a very high level, kind of what the current law is, what the amendments are, what the initiative would do. And then I have some proposed language that I will offer to you all that I just think you might understand better what my concerns are. I'm really going to do this at a very high level because it's complicated. So under the current law right now, today, decisions regarding the development, construction of energy facilities are made at a local level right now.
If I can, that's as of right now, because the law that's in
Right,
contest.
so I'm going to get to that.
Okay.
Yep, don't worry. I'm not going to be disingenuous. I'm just saying
I was just making sure that that.
Yes, right
Sure.
now, if, you know, the process right now in place
Are
is.
are you talking energy facilities as in power facilities or is energy facilities as in solar, wind? and-
Solar, wind, energy
Okay,
storage.
I
That's
just
how
want,
it's
I
defined.
know I'm
term.
going high level, but
Yes,
when you say energy facilities,
it's not all energy.
not all
Energy
energy
is defined in
facilities.
the statute, which
Got it.
includes, you know, certain solar and wind and
There you go.
energy
Thank you.
storage facilities only.
What you're saying is that what is in effect right now is what has been implemented by.
Well, the amendment doesn't go into effect until November 2024.
So that's what.
That's what
what-
Mr. Don was saying.
Okay, so
So that's why I just want to explain. That's part of what makes us confusing
I'm
is.
very confused.
Yeah,
Help me
so
out.
let me try and do this at a high level and hopefully, you know, we can just get to the summary part and try and get this done. Because I think we could be here a really long time. This is like a whole series of amendments. It's confusing. And I had to take some time. 'Cause this is not my area of the law. So to try and figure it out as well. So right now, the process is these decisions are made at a local level. Okay, they're subject to local zoning, local ordinances. Decisions are made by the local officials that represent the community in which these facilities would be located. In a series of amendments that were passed in November of this past year and signed into law, that process will fundamentally change starting November of 2024. So it's a year before it is implemented. And the primary changes are one, the standards that an energy facility must meet in order to develop and construct a facility in Michigan are governed by state law. So they set forth the standards that any such facility has to meet. So unless a local unit of government has an ordinance which is compatible with these state standards, which is defined as not more restrictive than the energy company has no obligation to go through the local process at all. And they don't need to get any local approvals. That's just how it works. If a local unit of government has an ordinance that is deemed more restrictive, which is then not compatible, or they have a moratorium in place on the development of these types of energy facilities, that is also deemed incompatible, and the energy company does not need to go through the local process at all. They just go to the state. So if and only if the local government has an ordinance that is compatible with the state standards, which is really means the same, then, and that local unit informs the energy company that they have a compatible ordinance, then that company has to apply locally. So they go through the local process. And the local's unit of government has only 120 days to analyze an application and decide whether or not they are going to approve it or deny it. If they approve it, great. And then everything moves forward at the local level. If they deny it, or if they do not respond in 120 days, then the energy company or developer or whatever, then they just go to the state level and they bypass the locals. So even if the locals deny, so essentially the local denial is pretty meaningless because then they can just go straight to the state and go through that certification process. So the initiative, this initiative before you today would repeal those changes to that process and essentially put us back where we are right now. That these decisions would be made by the local government, local zoning, local ordinances, and the local officials in the communities in which the facilities would be developed. So we're essentially returning it to the status quo. And that's at a very high level. Whether these amendments are good policy or bad policy is not really for us to debate. It's not relevant to the summary, but I felt it was important because I think it is confusing to just kind of understand at a high level what we're trying to do. So with respect to the summary proposed by the director, I really worked hard to try and kind of work from that summary because again, I do think we should be giving deference to that. If I could. So what I've given you is on the top that's highlighted is the director's proposed summary. I've highlighted the sections that I have concerns about, which I will talk about. I thought it'd be easier to highlight so you know what I'm kind of focused on. The second one is my proposed changes in red line. And then the bottom one is just that clean. So the concerns that I have relate, they're all kind of grouped together. The first one, and I actually agree with Mr. Brewer, so that should be noted because it doesn't happen that often and probably won't happen again today. So the part about eliminating the requirement that applicants undergo state certification before construction of certain wind and solar facilities. I don't think that's entirely true because, you know, the statute does say that somebody may go through the certification process and there is a path, like I explained, if a local government has a compatible ordinance and they go through the process and they approve it, that it would just stay with the local government. So I don't think I just don't think it's entirely accurate. So and you can see, I tried to propose some changes that would address that. The other thing, this is just a smaller issue. I think the undercurrent law is a little confusing because as I explained, we have kind of the law that's in effect now. We have the law that's coming into play in November 2024. And that's really what we're making changes to. And so I don't really feel strongly about it. I just think it's a little bit confusing. And then the third thing that I really have trouble with is where it says under current law, in addition to local approval. There is no local approval required under these amendments. That's just not true. I mean, in fact, the sponsors were pretty transparent that a very large reason behind this amendment in particular was to preempt local control because, and Mr. Brewer alluded to that, because they felt like they weren't getting the approvals that they needed at the local level to get the number of facilities up and running. So that was really the primary reason of doing this, was to take away local control of this process. So to say that local approvals required or suggest that local approval is required, I would just, I have the biggest issue with that because it's just not categorically untrue. And then again, I mean, really the purpose of all of this is all about local control. I mean, that's what this is. What we have now, the amendment is to preempt it so that more of these can bypass the local process and go to the state level. And this initiative would seek to return us to the status quo. And so I feel like we need to put something in the proposal about that's what this proposal would be doing. Now I'm, you know, open to other language. That's what I added at the end, that there has to be something in there because that is the purpose, is to put this back into the local control and decision-making process. So that is where my issues and the language that I propose. You have any questions about that?
You know, I have a question which goes back to my initial issue with regard to the language. And you say that this is the way the legislature does it, which I understand, that's fine. But what we're looking at is a petition that is going to be, where the proponent is going to be soliciting people to sign it. And the initiated legislation doesn't tell them anything, except that it repeals Section 8, Part 1, Section 8. And I guess, you know,
This is one though, I'd be different with that. Her summary
yeah.
tells me everything I need to know. I would make the
But you
decision
don't
based
know, you don't know if it's compliant, if it reflects what the statute says, do you?
I only know that the pieces of the statute that are affected are in the main proposal.
Oh, you mean 1221 to 1232?
That's just been repealed completely, so it doesn't tell me what that is. Is that what you're?
Yeah, that's what I'm saying, that on the petition itself, it's not gonna, it doesn't tell people anything. And the only way they know what it's about, I mean, what we've been doing before, and I understand what you're saying.
Yeah, when we did that, once I was opposed to the repeal of the prevailing wage. It just said repeal. It didn't list anything. And
Right, that
nothing.
that
There
may
was,
be true, but I'm looking at this and I wasn't there on the prevailing wage, and I'm just trying to figure out what somebody is gonna take from this. So that makes it particularly critical that the summary be accurately and informative. So I'm just, I haven't picked through the statute, and I know what the director has tried to summarize and what you have summarized and what Mr. Brewer has summarized. And it's just kind of hard for me to, at this point, to put these pieces together and figure out what gives us the accurate, non-prejudicial purpose of the initiated legislation. I don't know how to describe my concern more. I'm kind of baffled, and I'm glad that that member Bradshaw has been involved a little more and has some greater understanding of what this is about. At least I hope you do. Are you satisfied that you understand what?
This version of the 100-word summary puts it in perspective for me, yes.
Proposed changes to summary.
If I were reading this, I would basically come away with the idea that, if I'm hearing you correctly, decisions for wind, solar, and energy storage belong in the local community. They don't belong on the state level.
well, that's what the proposal
I mean-
is, yes.
I mean, that's as simple as I can boil
Right.
down what I'm reading.
Right.
The question that Ms. Growitz is asking you about that section of the law that you're repealing and not reflecting that in the proposal. You want to comment on that, or?
I think I have. I mean, I think we are obligated to follow the legislative process. And again, I did take the time to look at every single petition that has done even a full repealer. So there was one for the emergency, I wasn't involved, the one that was during COVID, it was a full repeal. It didn't have any language of the entire statute. The prevailing wage one didn't. I think there was one years ago on the single business tax. So there've been multiple where there've been full outright repeals where literally they've just said this act is repealed. Now, in this case, we're not repealing an entire act, which is why it's an amendment. We're repealing certain sections. And again, in Raise the Wage, there were certain sections of the Improved Workforce Opportunity Act that they just said repealed. I didn't have an issue with that. That's the normal process. That's how they do it legislatively, and there's all sorts of protections under the legislation with respect to amendments and such, to make sure that people are informed of what the changes are. And I understand what you're saying. I mean, and this is why I actually gave this some thought and reflection in terms of, what would be the proper process here. And so I looked at what the legislative process is. I researched what the requirements were under the legislation, and I looked at all the prior petitions, and this is consistent with that process. It identifies what the statute or the statutory sections that are being repealed. And frankly, it's probably a lot easier for someone to look that up than to look at me putting an 8-point font and crossing it out on a petition and having someone try to read multiple pages of what is already a complicated part of the statute. So I'm not sure that that would really be giving anyone anything because it would all be crossed out.
I guess my question is, this is not to you, this is just how this is written. That last sentence says enacting section 1, part 8 of the Clean Renewable Energy and Energy Waste Reduction Act. And then goes on to list the public act, and the MCL is repealed. I guess what's throwing me off is the word enacting.
That's just how it's done
I figured that's
legislatively.
why I know,
That's just how it's done.
I'm looking at that. I think for me, that was the one part when I was reading through, I'm like, okay, well, for enacting it, but if it's repealed,
Yeah. That's the process. We even looked at the legislative manual, you know, in the book. I mean, this was not done without thought, you know, and making sure that it was compliant. Given I am usually on the side challenging petitions, I am extremely careful when drafting them to make sure that everything is compliant.
So are the statewide requirements a minimum?
I guess so. I mean, they can't be more restrictive. An ordinance cannot be more restrictive. So I guess they're not a minimum. I mean, I guess it depends on how you look at it. So you have to, a local government could not make it add additional requirements. So I guess it's more of a maximum. Kind of a minimum and a maximum, because it's just, this is what you have to do, right? And then the locals aren't allowed to do any more, right? So essentially anything that is inconsistent with that, I guess a local in theory could be more lenient if they wanted to be.
So they could
be more lenient. But they certainly couldn't be more restrictive. I mean, that's clear on this, that if they tried to impose any additional obligations or requirements on a energy.
So
company.
long as the local requirement is not more restrictive than state certification, then they don't have to go to the state. Is that correct?
As long as the local ordinance is not more restrictive and they approve it.
And
they
who
approve
approves it? The local?
The local approves it.
Right. So if the local scheme for considering proposals, I guess, if they're if they are not more restrictive than the state, then the state doesn't get involved at all. Is that
Only
correct?
if the locals approve it. So they could
Okay,
have a
well,
totally
and
compatible,
if they approve it, then what happens?
then it just stays with the locals.
Right, so.
Right, it's
Right,
regulated.
So the state is essentially saying, this is what it should be, and if the local government is, if its standards are compliant with that, then the state doesn't get involved at all.
Unless
the local government just goes
government
ahead.
doesn't, unless they deny it. So the local government could have an ordinance that has the same exact standards as the state. They could do their own assessment and they could determine that the applicant is not compliant with these standards and deny it. And then the energy company is not bound by that. They just go straight to the state.
That's the real power of what you're putting together here is that if the local community says, no, we don't want this, the energy company can't leapfrog over them and go across the street here and have somebody bless it.
Right, because that's what this would allow. I mean, that was the purpose of it, is to allow the state to supersede the locals. I mean, really, the locals, the only, if you want to call it control, but it's really no control. The only thing locals can do is have the same exact standards of the state and approve it. If they do anything else, if they don't respond in 120 days, and mind you, the locals have 120 days to respond, the state has a year, you know, and these are really extensive applications and such. They don't even have very much time to come to a decision on major development. So if they just are like, we can't do this in 120 days, and unless the energy company agrees to an extension, the company can just say, well, you haven't given us an approval in 120 days, we're going to go to the state. And again, I mean, whether this is good or bad policy really isn't, you know, I'm not going to argue for or against it. That's not what this should be. This is really just how it works. And so that just needs to be reflected in the summary, I think, in terms of how it works and what would change if this initiative is successful.
Madam Chair, so we've heard from Mr. Brewer and we've heard from Ms. Hanson, and I can tell that Director Brader is typing over here. And I'm looking at and we are absolutely serious. I've been in this room where the Senate security have walked in and said, we're done. So
We done at 4 o'clock or
4:30 and we have to be out. So I'm wondering if it's possible if we let Director Brader kind of give us, or I guess the question for you as the chair is, I know we had a lot of people who wanted to talk.
We do. And
So I guess maybe we get through the public, the comment, and then I'm sorry, I don't mean to.
Well, I'm guessing, I mean, I don't want to speak for all the people. I don't know everyone who signed up, but I think everyone, it's the highest priority is to try and get the summary approved today. So, I mean, it's up to them to decide whether or not they.
Is there,
Print out, I did work on a different one. I can print it out. While we're printing it, we can have public comment and then talk about, revise some.
you're proposing to print out which?
I've been working on some revisions, trying to incorporate Mr. Brewer and Ms. Hanson's remarks. I don't know if they'll necessarily agree with it, but I could work with Adam to get that printed out while we're having public comment. We could discuss it afterward.
And I'll just offer if Ms. Hanson were agreeable to two changes to her proposal, it would be agreeable to me.
I'm sorry, would be what?
If she would be willing to make two changes to the language she just proposed to you, which I can discuss with her, we would be agreeable to the summary. May I have a few minutes to do that?
you're asking to speak with her and then?
Yes, if I may, you can take your testimony and keep proceeding. We may be able to work this out. I only need it. I would only suggest
You guys are gonna work.
we're gonna talk to each other. That's okay.
You
We're
wanna
gonna try to
take
work it out.
Director Brader with you
He's welcome to join us.
and, or, yeah. Okay,
So we can have public comment.
okay. Yeah, Edward Rivet from Michigan Conservative Energy Forum. I think we've heard from you before. Maybe it was on farmland.
Pardon?
We heard from you before, as I
Yes.
recall, on farmland.
Yes, indeed.
How long do these folks get?
2 minutes,
2 minutes. Wow. Okay, well,
because we've got a lot of people.
I will skip my disclaimers, but they include my involvement in a variety of petitions and writing the law in 2018. I was directly involved in that. I also am the chairman of the Aurelius Township Planning Commission here in Ingham County, but anything I say with regard to that, our experience in Aurelius Township is not an official position of the township. And I would like to echo just that there are certainly some factual problems with both the proposed summary by Citizens for Local Control and the director, which have been pointed out. So I won't go into detail on those. But what I agree with you, Madam Chair, that the problem is when you have, and it is a legally correct form to just say Part 8 is repealed, that's the right way to do it. But then the only thing the voter gets notice of is what's in the summary. That makes the summary way more important than it usually is. Given all the conversation, including on the tax one, there should be some effort to explain to the voters what it is they're throwing out. If you're going to repeal Part 8, you should know what is in Part 8 to some degree. And so there are some features, as Mr. Brewer's also highlighted, I would like to reinforce. The reason the legislature passed this law is because local units of government for the past 5 years or so have been practicing exclusionary zoning, which is blocking project after project, and it is now beginning to affect, as the utilities have testified, the availability and reliability and affordability of our electricity supply. The legislature felt compelled to pass this law because we were not going to keep up with the state's needs for electricity. And so there became a pressure to balance our state's broader electric needs with local control. So as you see the fairly complex process of this legislation, not all the parts we agree with, by the way, when we testified in support of the bill, we said, but it's not exactly the best version. It's important for the voters to know why the legislature felt it was important to restructure and balance the process by which projects are approved. So that's key for the summary for people to understand. If we repeal this law, we threaten things like our electric reliability and our costs. So I think that's an important element. The other, my last point that no one seems to be mentioning, and this is why as a planning commissioner, it's important. This should start with, this affects energy projects, and I don't think Ms. Hanson mentioned it either, of certain sizes. They had to be a certain size. And this is relevant because we in Aurelius Township rewrote our ordinance to allow for a 20 megawatt project, which has been built. It just got built in the last year. They just turned it on this month. And it's below the threshold of this law. So we as Ingham Aurelius Township and our planning maintain complete control over that project. And if another project of that size were to come to us, it would remain completely in our control. So there's a real inaccuracy here in not indicating that it's certain size projects. So that absolutely has to be in the summary. So.
Thank you very much.
Do
I'm
the best I
sorry
can.
we couldn't hear
I
more from
understand.
you.
It's been a
because you're
long,
very-
long day.
We all have, right? Kevin Heath, who indicates that he is a landowner who wants to keep his property rights. Mr. Heath,
Hi there.
try to keep it to 2 minutes.
Yes, ma'am. Thank you for you guys being here. Kevin Heath, Mylan Township. I've been on deputy clerk for Mylan Township for about 10 years. It's despicable what's happened in the last. Mr. Rivet said they've come in, they've taken over. They don't want it because they don't want to see it. I want my property rights. Nothing is said in here about my property rights. Nothing said about the size of the project. Nothing said that they have to pay the township a fee. I urge you to read the bill first and then look at what they're trying to say, because this just doesn't come anywhere
Look
near.
at what who's trying to say.
Yeah, in the director's summary, you know, because you need to let the people know. We're here today because they took the local control away because of the outside forces that came in and recalled everybody to get what they want. We have boards now that have no clue, never been to meetings. And that's why it's important that it's explained to people and they know what they're signing. Because we should have our property rights, and I can't do on my property what I'd like to do, and I'm trying to save my family farm. Because they don't want to look at it. They can put a roof on their house, color they want, and I can't say what they can do, but they want to say what I can do in my property to earn money to save my farm. Anyway, they just need to explain to the people what it's about, because this doesn't explain to people. It's very confusing, and I understand the bill. And
You can
it's
see
just
how
very
confused I am. I'm even confused about what your position is, because are you, I'm being.
I'm again,
Are you saying that you want to be able to?
the state stepped in because the locals are being controlled by big money and outside sources because they don't want to look at the solar. They're telling me
You
what I
want solar
cannot do.
panels on your farmland.
Yes,
Okay.
period.
I'm just.
and it doesn't say anything about local control, and they should say, people don't understand that they've taken our local control away already.
So I think if I can understand you correctly, that when you're talking about local control, you're also talking about the property owner's control, not necessarily about the township.
Correct,
Is that correct?
correct.
So we've got
Replace
the
the local
property owner,
officials.
We've got the political jurisdiction, and then we've got the state. And they all have interests.
And they've
which-
recalled anybody that's had common sense and understood the ordinances to get what they want, to not do the projects. That's why the state had to step in and say, we got to do something.
Yeah, that's helpful. Thank you.
Thank you.
I'm sorry. Okay. No, we're not going to get through everybody. We have Dr. Wanda Izzo. Oh, so you're right there in the front and you're the right person for me to
here.
call.
I'm
You're
in
Ingham
Wheatfield
County
Township,
Citizens
yes.
United.
Yes, but I'm gonna come forward as a physician. And the reason I am is because if renewables are not cited correctly, it becomes a public health issue because of the infrasound and the sound. And people, and the reason I'm worried about the takeaway of local control, I am a proponent. I want to see the local control back because especially in Ingham County, we're not just stupid NIMBYs. We are educated. We use expert advice, Dr. Punch, audiologist, and Rick James, acoustic engineer. And I have looked at the WHO, World Health Organization. What are their standards for health and public safety? And the state bill blatantly disregarded, in my opinion, public health and safety. 1,100 feet is not safe to be away from a turbine that's 650 feet that can throw ice 1,500 feet next to a property line into my land where I have my property and I grow hay. I'm a farmer too. I don't know why, but I am, and hurt my horses and my children playing on my property. That law just disregarded some very important public health and safety issues. And the deep decibels language is 55 decibels average. Do you know that the World Health Organization proposes 40 or less? Otherwise, it affects hearing and tinnitus and motion sickness and our inner ear issues, autism, flicker may affect people with seizure disorder, the shadow flicker. Anyway, all those things were disregarded. And I thought, oh my goodness, if the state can't protect our health and safety at the state level, then we have to go to the local township level. And we're not just NIMBYs. I know he was saying, we're just blatantly saying no, but we're not. We're
Thank you
having
very
some
much.
expert advice.
Thank you. Getting different perspectives on this from different people,
Thank
and
you.
that's very helpful. Dick Farnsworth, Patriots for Montcalm. A minute and a half.
Thank you, Madam Chair and board members. This is a complex law. I think there was like 8 bills involved in this whole thing, and they're integrated in certain ways. But when we talk local control, up until this point, zoning ordinances were done by the local townships, villages and whatnot. Along comes fairly technical solar, wind farm, that type of project. The board members didn't really have a good grasp of what this was all about. And they struggled for a while, but as we've heard before, outside people have come in and stirred up issues, spread false information, done recalls to get rid of the current board members and installed their own people. This caused the state to have to step in because they are not meeting their green energy goals and their carbon zero timelines. So they did pass this law. And it turned out to be, in my estimation, a pretty good compromise. The local, we've heard the locals, you can apply for a permit from the local government, and if you get it, fine. And it has to still be within what the state has set as regulation, either max or min, depending on what parameter you're talking about. If the local ordinance is restrictive, which most of them are now after all this, then the petitioner can petition the MPSC. And there's a $75,000 fund that's set up by the petitioner for the township to go to the PSC and argue legally and get what they can get. And 2 townships can go together with 150,000. So there was some good compromise in there. They didn't lose total control, but the state has to move forward. And if we want to live in a clean environment going forward, this is going to have to continue. And the language I'm even hearing now, just really, I'm sorry. It's not telling the people that are looking at the petition what they're going to lose if this petition is approved.
Very much.
Thank you.
Director Brader, do we have an agreement on language?
We do. We're going to print it out, but obviously you have not looked at it. So if folks want to keep commenting, we can print it out while that's happening.
Okay. Bill Richardson. Mr. Richardson sent us a very long and well-written, detailed position letter. So Mike Brown. I have not asked people to state their and spell their names for the record, but let me ask you to do that, please.
Okay, my name is Mike Brown, MikeBrown. So I am a vice chair at our planning commission at the township that I live in. So when they talk about people coming in, taking over their townships, chairs and boards and all that stuff, that's not really a true statement of how it goes everywhere. Our township, as he had stated, wasn't really that up on solar, wind facilities and all that stuff. So we educated ourselves. We found out both sides and we made a decision for our township of what was good for our township of a size of these facilities. And with what they did with the new bill 233, they took that away from us. They will not use our ordinance because it does not exactly match what the state is asking for. And what the state is asking for is a bare minimum. It's 50 feet off the road. We were asking for 300 feet off the road. And if you go to DTE best practices, it is 300 feet off the road. So that we are not even using what a developer uses for their best practices with the new law that is going to come into effect next year in November. So when you say, is this a minimum? Absolutely, it's a minimum of what they're asking for at the state level for us to accept in our communities. So they definitely took away our control because it is, all they have to do is say, we do not have a compatible ordinance with the state. And then they just go straight to the state and we have nothing to do with it at that point of controlling any of it.
Thank you.
You're welcome.
Beach.
Clint Beach,
Okay.
CLINTBEACH. I'm a small farmer, Cohocton Township, Livingston County. I am also on the planning commission for Cohocton Township. You guys probably know this, but one of the greatest things ever created was a committee because you have to listen to everyone's voices. One of the worst things ever created was a committee because you have to listen to everyone's voices. But that's kind of the point, isn't it? Right? To listen to everyone's voices, right? And that's what the local governments are set up for, right? That's what the local planning commission is for. That's what the local board is for. That's why we have committees and communities. Since this has started, since these bill, before it gotten voted on, I've tried to talk to the Senate. I signed up to have my 3 minutes and was denied because they went to lunch. Okay, today, not everyone's going to be able to speak because we're time frame, right? That doesn't happen at the local level, right? Everyone gets a say. The farmers who want it on their property gets a right to say their say. The ones who don't want it have a right to say what they want to say. This is what this is for. This is what the initiative that we're proposing is meant for, right? Is to take everyone's voice, everyone's vote. The whole point of democracy is local government, the right and the ability to self-govern.
Thank you, Mr. Beach.
Thank you.
You know, we're going to be able to hear everybody. So Jason Wolford.
So that was my point. Right?
Yeah. And I appreciate that. And it's hard when the day is short, but is Mr. Wolford here? Nancy Laskowski.
It's Laskowski. Madam Chair, thank you for allowing me to speak today. I serve on a local planning commission, actually 2 in Tuscola County. And I want to speak to the language, though. I wanted to make sure that the language possibly included that this was returning, the current law returns, he has power at the Michigan Public Service Commission rather than with our local communities. Our local communities are best situated to take care of the health, safety, and welfare of our communities because we are in touch with them. So that was primarily what I wanted to hear. And also that the, I don't know if you need to have the language, but also to your question, Madam Chair, when we write a new zoning ordinance amendment, we're actually writing a new piece of local legislation, basically. So we write a new ordinance that would amend and repeal, and that could be the only language that it actually says is we're amending or repealing, but we're writing a new piece of legislation, just as that would be a new act. When this would be implemented, it would be a new act, but it would be repealed. So, okay, thank you.
So this has been helpful. We've heard of diverse voices and the proponent and that's it. What? No. The proponent and
One more person wanted to speak.
There's one more person. His name was Stephen Weiss.
Oh, I'm sorry.
I thought I saw.
Oh, you're right. Stephen Weiss. I'm sorry. Oh, you're also from Conway Township, right?
Yes, ma'am.
I think you had put it under when you.
Stephen
Oh,
Weiss,
yeah.
STEVEN, I'm from Conway Township. I do believe that the zoning for these projects should remain in control of the local governments, just as the previous lady stated, because we are in touch with our people in our community. We know what they want, what they don't want. Now, regarding the farmer or farmers that say we shouldn't be able to tell them what they can and cannot do on their land. Well, I don't want to do that, but when what you do on your land affects me and my land and my neighbors, now we have a problem. Okay? The state doesn't look at it that way. They've got a flat set of parameters that are a bare minimum. And they want to override what maybe we want to have little stricter ordinances. Yes, because we don't want to have 5,000 acres of solar panels in a small little township. How about 100 acres, 200 acres? Oh, no, that's not good enough. They want to have at least 100 megawatts. Okay. But again, they don't consider any of the drain tiles. And we've seen this in Shiawassee Township or county. They tore up all the drain tiles in the farm fields out there. They had massive flooding. The homeowners had to use their own money to go back and try and fight these developers to get their drainage problems fixed. That minimum that the state has, it doesn't even mention it in there about drainage issues. And I could go on for hours about this, but we've already been here a long time. But I believe this should stay at the local level.
And we do have agreement about what the petition is going to say, and there are going to be such interesting arguments about whether people should sign or not. And
I agree, it should be a lot more clear.
It's gone.
I could explain.
And it has been, we haven't had enough time for this, but I've learned a lot already and I expect I'll learn more. Director Brader, do you want to read the summary?
Yes, I've also learned a lot. I've also learned a lot this afternoon. So the revised proposed summary is something that both sides agreed to, but I'll just read it here. And the board can consider it, of course. This is 82 words. Initiation of legislation to amend the Clean and Renewable Energy and Energy Waste Reduction Act by repealing statewide requirements for the construction and development of certain wind and solar energy facilities and energy storage facilities, including assessment of environmental, natural resources, and farmland impact, wages and benefits requirements for workers, setback distance, size and height of structures, and amount of light and sound emitted. If enacted, this proposal would allow local units of government to determine their own standards for such facilities.
I just have a question. This is a question, and I think it was brought up just by someone. When we're talking about certain, you guys can shoot me down, okay? But certain size, wind, solar, and energy. Because the legislation does have, sorry, I was scrolling around and I'm not really used to this computer yet, but it does have sets for what size units that we're talking about, not just, I don't know, Steve wants to put a 15 kilowatt, like a 15 kilowatt, solar panel to make sure that his shed has power. Right? Like I just want to make sure my other board would a certain size, or am I opening Pandora's box?
I think Pandora's box, to me, certain is enough of a
Okay.
qualifier that
Okay. So we have this summary.
Addressing a public comment. So.
Do we have a motion?
Can I make a motion?
Yes.
I move that the board approve the form of the initiative petition submitted by citizens for local. Oh,
That's the form motion.
oh, you know what? I got the wrong one. Sorry about that. We've been here too long.
We got 4 minutes.
Yeah, let's see if I can find it here. There we go. I got it. I move that the Board of State Canvassers approve the summary of the purpose of initiative of the initiative petition sponsored by Citizens for Local Choice as drafted by the Director of Elections and presented by the Director on January 19th, 2024.
I'll support.
All in favor?
Aye.
Aye, motion carries. And we also have the approval as to form, that is item number 9 on our agenda. We understand that Member Bradshaw will not conditionally approve the form. Do we have a motion with regard to approval as to form?
we will in about 13 seconds.
Okay.
I move that the board approve the form of the initiative petition submitted by Citizens for Local Choice with the understanding that the board's approval does not extend to 1, the substance of the proposal which appears on the petition, and 2, the manner in which the proposal language is affixed to the petition.
Need a second, I'll second it.
Moved and seconded, all in favor?
Aye.
Aye. Opposed?
Aye.
Or nay, whatever.
Nay. Nay, whatever,
Okay.
whichever you wanted, but
All right,
if
so-
I'm not approving a conditional approval form, that's. I don't think I need to explain it again.
Yeah. Okay, and what the condition, of course, is that the language which we have approved be affixed to the petition.
Yep.
Word by word.
Got it.
Okay. So we had also on the, we have a couple minutes to approve the following dates for the Board of Canvassers regularly scheduled 2024 meetings. That's, I don't know if I need to read this out. Do I? You want this on the record? Okay. February 16th, March 18th, April 26th, May 6th, May 31st, July 19th, August 26th, September 6th, October 18th, November 22nd, December 2nd, December 11th, and December 20th.
I'll make a motion to accept and approve the regularly scheduled meetings of the Michigan Board of State Canvassers for 2024.
All in favor?
Aye.
Aye. Okay, the motion carries. We were going to consider our recommendations regarding proposed legislation, but we're being kicked out. And so we're going to defer that to the next meeting. Is there any other business? Oh, I really want to congratulate the parties on coming to agreement. It's difficult. It's difficult for the director and for all of us, but this has been a really productive meeting. Very productive. So thank you to everyone. And I really thank the people for staying around all day and educating us about the complexities of this issue.
And you guys all be
Thank you
careful.
very much.
Some of you have a long distance to drive, so drive safely.
May I say one thing, Madam Chair, before anybody, if there's any media in the room that would like to speak to the board, if I can ask that you go in the lobby and get the board members in the lobby so we can clear the room out. Thank you.
Hearing is adjourned at 4:28.